Amit sir, can we begin the session and then
Yes.
other participants would join in a while?
Yeah, sure.
Okay, just a second. So, sir, I'll just take around 3-4 minutes to have my, the briefly introduction part, and then I would request you to start your session. Is that fine, sir?
All right.
Okay, thank you. So, dear all participants, our speaker for today, good morning and a warm welcome to all of you. So for today's session, we have Amit Gupta sir here with us. I'll take, as I said, 2-3 minutes to briefly introduce sir and then request sir to start the session. So sir, as you all would know, is an insolvency professional and a fellow member of the ICSI. Sir is passionately engaged in the practice of the profession for the past more than 2 decades. And the areas of practice have been related to corporate and allied laws. Now, in that area, sir has been providing some out-of-the-box solutions to the problems which concern complex legal and strategic management issues. If I talk of the qualifications, sir is a science as well as law graduate, as also a company secretary. And sir also holds a diploma in banking and finance from Institute of Chartered Financial Account Analysts of India, ICFI. In terms of other association contributions, Sir discharged function as a member of NIRC of ICSI from the year 2015 to 2019, then also from 2019 to 2022. Now, Sir was the ex-officio member of the Managing Committee of Lucknow chapter of NIRC of ICSI for these years, as I mentioned earlier. Sir was also a member of the Management Committee of Lucknow chapter of NIRC of ICSI from 2007 to 10, and then from 11 to 14 as well. In 2011, Sir was also the chairman of the Lucknow chapter. Apart from this, Sir has been the chairman of Research and Publication Committee of NIRC of ICSI in the year 2019. Sir has been a member of the Secretarial Standards Board, Auditing Standards Board, Core Group on Vision New ICSI 2022, Task Force on Corporate Law. Sir has also been the chairman of Core Group on Corporate Law Publications. Sir has been a member of Research Group on Companies Act, chairman of Research Committee of NIRC, and member of Core Group on Governance and Compliance Board report statement. Now, Sir has contributed extensively in different publications of ICSI, and has also contributed through his lectures and sessions at different forums, which includes the Management Institutes, the Professional Institutes, the Chamber of Commerce, National Law Universities. So these are the few institutions that I can name. So I think I can confine my introduction part to this much, and I would straight away request her to start the session. Sir, over to you.
Thank you, Nitin, and thanks to ICSI IIP for giving this opportunity to interact almost for a whole day with the learned professional members of our profession. Nitin, I hope I am clearly audible. Nitin?
Yes, sir.
All right. I just wanted.
Yes, we can hear you clearly, sir.
All right. Thank you for responding, and we look forward for the very good interaction, especially in the backdrop of the topic that ICSI IIP has chosen for deliberation today. I know I am taking a time from the weekend, and I know what it means for a professional. So we will try to make the best utilization of the weekend if we are taking out time from the holiday for the purpose of updating and educating ourselves. So we hope that with interactions, whatever we are going to do in the course of day, it will be useful for both of us as well as the development and evolution of the insolvency and bankruptcy code as well. So what I have charted out for the discussion today, because we know, I think it's been quite long time, more than 6 years from the time when the insolvency and bankruptcy law was enforced. We will take maybe a 5 minutes background, although I am aware that all the participants are in practice of insolvency, and they are familiar with the length and breadth of the insolvency and bankruptcy code, and it need not be repeated. But just to highlight certain points and understand the very objective for which this insolvency and bankruptcy code was enacted, and how the judicial intervention over a period of time has enabled the evolution of this insolvency and bankruptcy code over a period of time to resolve various issues, to come out as a solution what the government has been intending. Nevertheless, no law is ever perfect. So is the insolvency and bankruptcy code. And that is how I think any law is drafted. So when the enactment of insolvency and bankruptcy code was done, then the thought was that we create a comprehensive framework so that it becomes a panacea for all ill issues with regard to the stressed asset in a organization or in an individual or in a partnership firm. And that's the very reason why this was enacted as a code, not as a act. We all understand that in our country, we have a few legislations which are enacted as a code, and rest all are enacted as an act. Like Companies Act is a enactment which is enacted as an act. Whereas Criminal Procedure Code or a Civil Procedure Code, and now the insolvency and bankruptcy is also enacted as a code. So if we compare, we will understand the very objective. The objective is, like if we compare it with Criminal Procedure Code or Civil Procedure Code, like civil procedure is a law, is a code which encompasses anything and everything with regard to the civil litigation. Whether it is a matter relating to a district court, whether it is a matter relating to High Court, whether it is relating to Supreme Court, as far as the matter relates to civil procedure, you will get your answers in CPC. Similarly, if a matter is relating to criminal procedure, you will get all your answers in a criminal procedure code. With that objective, the enactment of insolvency law was made as a code to encompass the insolvency resolution of a corporate person, which includes a company, which includes a limited liability partnership, and the other corporate form of business. Similarly, it also encompasses the liquidation of these corporate person, then individual insolvency, whether you are an individual who is doing a business, whether you are an individual who is doing a service, or you are an individual who falls into the category of a guarantor, personal guarantor to the corporate debtor, or it is an insolvency resolution, or it is a fresh start process, or it is a bankruptcy with regard to the individuals. Everything is covered in this particular framework, including the statutory authorities which have been constituted, including the processes which are required for completing this particular process, and above all, this is a law which is having a non-obstante clause, which has been a subject matter of debate quite a lot in the last 6 years of time. Section 238, by way of Section 238, which gives a superseding power by and large to all the enactment which are there in force. So this law came in a backdrop that there were certain shortcomings, like prior to this, there were multiple legislations. So the problem of multiplicity was tried to be resolved. The problem of multiplicity of jurisdiction, the problem of multiplicity of legislation, the problem of multiplicity of forums. All these three multiplicities were tried to be sorted out through this Insolvency and Bankruptcy Code by way of creating a comprehensive code. Another problem which was there in the Sikh Industrial Companies Act, SICA, which came somewhere in 1985, was that it was not covering all kind of business entities. It was restricted its applicability to industrial units. If you are not an industry, if you are a service class, then that particular business was out of the ambit of SICA. The government thought that yes, there is a requirement that the law should be extended. The distress is a problem which is not restricted to any industry, but it is extended to the other entities also. So with that thought, the extension was made for all kind of business entities. Of course, its applicability in the first round was restricted to all entities other than the financial service providers, for which the government thought that they will come out with a separate framework and legislation because of their own structures and the regulations, because Reserve Bank of India or the Securities and Exchange Board of India might be regulating, and the interest of public at large may be little different at a pedestal. So the thought was that. Another important shortcoming or change that the law brought was the earlier situation was that you were subjected to the insolvency process or maybe the revival process once your net worth was eroded. So if I am having a net worth of 100 crore, howsoever sick I may be, but I'll not be treated or I'll not be taken to the doctor unless and until I completely erode myself. And whereas the empirical studies which have been done over a period of time suggest that if you take the person who is becoming ill, who has the symptoms at a first stage itself, and you are taken to cure through a doctor or through hospital, the possibility and the probability of your revival and survival becomes more. With that objective, the law of insolvency made a paradigm shift from the concept of 100% erosion of net worth to a concept of inability to pay the legitimate debts. And now threshold was kept lower earlier, though later on when COVID embarked, the limit was increased, but still the threshold is 1 crore, with the objective that as soon as the corporate person is unable to make the payment of these amount of debt, it will be considered that there is some issue in the entity and the symptoms of insolvency are visible and the treatment is required. So treatment was by way of putting that entity into a corporate insolvency resolution process. So either entity would be resolved, that is the objective, because preamble also talks only about the resolution. Preamble does not talk about the liquidation. liquidation is a consequence. If resolution does not happen, the liquidation becomes inevitable and the companies are required to be taken to the liquidation. Another important shift that this law did was by way of prescribing a time frame. From day one to the day end, everything is prescribed with a time frame. In what time the application will be admitted, in what time you will be publishing the newspaper advertisement, inviting the claims, in what time you will be admitting the claims, collating the claims, constitution of committee of creditors, replacement of IRP to RP, and completing the entire process of CIRP. And if not, then what is the time frame in which the application has to be filed for seeking extension? And after extension also, if the resolution plans are not coming and or the adjudicating authority does not approve the resolution plans, then what is the time frame in which the liquidation has to be completed? So bottom line is that the objective was very noble, that the earlier issues and the challenges what the government and the stakeholders were facing with regard to the no time frame availability. So everybody was running their processes in their own sweet will. I still remember I started my practice as a company secretary in the year 2002, and I got associated with some of the BIFR cases, SICA cases, and till 2005, I think I was having as many as 10, 12 cases at a point of time. And when in 2016, 1st of December 2016, when the provisions of SICA got repealed by virtue of enforcement of Insolvency and Bankruptcy Code, I was having as many as 6 cases which got terminated, which got abated because of the commencement of Insolvency and Bankruptcy Code. But in the last 15 years, they could not be completed. So why I'm telling this fact is only that because the timelines were not there, so these kind of consequences were inevitable. I'm not saying in the insolvency and bankruptcy laws, we have not seen the delays. We all will agree. The intention was somewhat very noble. Later on, because when you have to do some learnings in the initial course of time, as we have also done, so everybody has taken its own time for the purpose of adapting this particular law. So we have experienced some delays also, and the time process of 180 days or maybe 330 days has got extended in certain cases up to 1000 days or even more also. But nonetheless, if we compare it with the past practice, what was prevailing, certainly a situation of having a time frame is always a better proposition. So with that objective, I think the prescription of time, though Honorable Supreme Court has stated in many of the cases that these time frames are directory, but still there is an obligation on part of each and every stakeholder who becomes party to the Insolvency and Bankruptcy Code to give an explanation if at all he is doing any delays in respect thereof. So with this background, I think whatever we have achieved in the past, the way the law has evolved, I think it is significant, and we all need to be patted for the same in contributing in some direct or indirect way in evolution of this Insolvency and Bankruptcy Code. Now, what attempt I am going to do with help of the learned 50, 60 professionals, I'm going to dissect some of the important Supreme Court rulings in a fashion that we are able to understand subject-wise as to what is the legal position standing today. If we are going to discuss, let's say, the financial creditor, or let's say dispute. So what was the position of dispute in the law, how it has evolved, and how the different courts have interpreted the particular provision, and what is the position standing on date in terms of the judicial pronouncements. Similarly, provident fund dues, gratuity dues, there is lack of clarity as far as the law is concerned. But over a period of time, judicial pronouncements had given us some understanding that how the treatment of these judicial pronouncements has to be applied while we are running a CIRP process or the liquidation process, so that we do not make any mistake or we do not take any wrong judgment while taking any decision in regard thereto. So that is the objective. We have just given 2 examples, but there are hundreds of situations, and I'm sure time is going to be short when we will start discussion on these subject. So let us begin. Slowly, gradually, we will keep on building, and my request is, as it's a very close family, I'm not claiming myself to be any different or any expert in this particular field, but yes, I have educated myself to make or start the deliberations on these very legal issues. You all, with your experience, can always supplement, can always add, and we can make further deliberations thereupon and agree to certain propositions as to what should be the way forward in this particular subject. So I'll share, I have not any formal PPT, but I have made a synopsis of various judgments. So I'll share the screen to enable you also to simultaneously read and respond to. Just give me a minute. If my screen is visible, can anyone confirm?
Yes, it is visible.
All right. So let's make it interactive, as I mentioned earlier also. So I'll begin with, and maybe once we make a momentum, maybe we will discuss more complex cases also. We are beginning with some of the very landmark judgments, which I'm sure we all are understanding. We will not spend much of the time on these judgments, but yes, because there may be people who are very newly introduced to the subject of insolvency and bankruptcy. So with that objective, we have prepared this document. So the very first issue that came was with regard to the constitutional validity of National Company Law Tribunal, National Company Law Appellate Tribunal, and also challenging the validity of various provisions of Insolvency and Bankruptcy Code. This issue was dealt by various high courts. Of course, by constitutional validity was questioned in dealing with the various adjudicating authority, by adjudicating authority and the appellate authority, and also by various high courts. Of course, through the writ jurisdiction, the high courts and Supreme Court had deliberated in length on these issues, and this issue got settled way back in 2019 by way of judgment of Apex Court in the matter of Swiss Ribbons Private Limited, wide SLP number 28,623 of 2018. So crux of judgment, we are just trying to understand. If there is any input from your side, please do feel free. So the crux says that Constitution of National Company Law Tribunal, which is adjudicating authority for the Insolvency Code, and the Appellate Court, that is National Company Law Appellate Tribunal, is constitutional. So the constitutional validity which was in question in many of the forums was rested, and Supreme Court declared that the constitution of these adjudicating authorities and the appellate authority is very valid and constitutional. And it is on the basis of the affidavit that the government of India has given in the matter, in the backdrop of the guidelines which were framed by Honorable Supreme Court only in the matter which was Madras Bar Association and the other relevant matters. Now, NCLT and Appellate Court will be put under the administrative charge of Ministry of Law. This was a direction which was given, although I agree that this part of judgment is still requires the implementation. So many of the legal luminaries have been making a question mark on the implementation of the judgment of Apex Court with regard to the subjecting NCLT and NCLAT under the administrative charge of Ministry of Law instead of Ministry of Corporate Affairs. Third part was that the scheme of law distinguishing between the financial creditor and the operational creditor was upheld based on the basis of distinctions which are mentioned in the BLRC. Absence of right to vote by operational creditor was upheld, and reference was made to the report. Insolvency Law Committee report was released. So that report has a reference in this particular regard as to why, because many of the operational creditors in turn had challenged this very issue. Why a discrimination between the financial creditor and the operational creditor is being made? So that issue was rested by Apex Court by saying that that is valid, and they have taken the reference from the report of the Insolvency Law Committee also. And the principle of fair and equitable treatment is incorporated wide Regulation 38 of Insolvency Resolution Process for the Corporate Person Regulation. This was also a question which was raised in various forums at Adjudicating Authority and Appellate Authority with regard to the fair and equitable treatment. So Supreme Court said that Regulation 38 is sufficient in this particular regard, and there is no requirement for further tweaking thereof. Then on information utilities, also a question mark was raised whether report of information utility will be becoming a mandatory or they are a prima facie evidence. So the Supreme Court stated that they are prima facie evidence and same may be rebutted. However, now when the government is contemplating the bigger role of an information utility in backdrop of the discussion paper, what has been released very recently in the month of December by the Insolvency and Bankruptcy Board and the Ministry of Corporate Affairs. maybe this particular part may require or may undergo a deviation as to what has been settled by the apex court. Another issue that was by way of, because as we all remember that there was no provision with regard to the withdrawal of application for CIRP. 12A was inserted later on when the Supreme Court was consistently passing the order with regard to allowing of the withdrawal application. Initially, the matter was placed before various adjudicating authorities, and various adjudicating authorities had passed conflicting orders, wherein few were allowing that withdrawal, few were not allowing a withdrawal on the pretext that there is no specific provision. Matter went to appellate court, and the finally matter was decided in the Swiss ribbons matter that government has introduced the provisions of 12A on the directive of Honorable Supreme Court in one of the matter, and they restated that 12A is not violative of Article 14. Because the question that was raised was, once the proceedings have started, once the admission has been made, when the proceedings are filed, they are proceedings in personam. However, when the admission take place, they become the proceeding in rem. So will it not violate the Article 14 was a question. And also the person who has filed the application should not have the right to withdraw the same also. So on these grounds, the 12A was being challenged, and the issue got set aside by way of this order. And it was mentioned that once CIRP triggered and COC is constituted, the proceedings become proceeding in rem, and therefore cannot be terminated by a single creditor. Where COC is constituted, the party may approach to the adjudicating authority, which shall exercise its inherent power under Rule 11A of the NCLT Rules 2016 to decide on the withdrawal. Section 60 of the code ensures that the committee of creditor does not have the last word, because many people were making a question mark on the wisdom of the committee of creditors also. So Supreme Court said the law is very balanced, and the principle of checks and balances is ensured throughout the act. It's not that that any particular authority or person will take on decisions without having any subjectivity, and the law is balanced in the sense that it will take corrective action on its own by way of appeal mechanism or by way of taking any corrective measures. In case NCLT and CLAT can always set aside the decision of committee of creditor in case the same is not just settlement. 29A was also questioned. The retrospective effect of the section is upheld, considering that the resolution applicant does not have any vested interest, because many of the resolution applicant and corporate person have raised this issue. As we all know, 29A again, which was dealing with the ineligibilities of a resolution applicant, was not originally in the Insolvency and Bankruptcy Code. It got introduced later on. So when it was introduced, the question was also raised in 29A. If you recall, there is a past history on the basis of which the eligibility of a resolution applicant is determined. So question was raised whether government can make the law prospective, or it has a power to introduce the provision retrospectively. So Supreme Court essentially in this matter stated that this is not retrospective amendment. The amendment is prospective only, where the conditions of eligibility has been checked or has to be checked on the basis of certain preconditions which are retrospective in nature, which is allowed not only in this law, but there are many other similar legislations where also the position has been upheld by the apex court itself. So that issue also got rested. So another ground was that there should be only malfeasance, should be only ground on the which the person should be held ineligible. So Supreme Court stated that cannot be the only ground. There can be many other grounds. The categories of related person in section 29A have to be read along with the famous doctrine and having the same flavor with the explanation 1 that was in relation to the connected person and the related person terminology that was used in the 29A section. Foremost objective of the code is reorganization, that is resolution. Liquidation is only last resort. This has been reiterated again and again. Judiciary should play minimum role in the role of legislature in framing economic laws based on the several Indian and the global laws. Section 53 was upheld considering the money paid back to the bank and the financial institution is infused back into the economy to further lending to the other entrepreneurs for the business, because 53 was also, so by and large all major provisions of the insolvency and bankruptcy code, the constitutional validity of these provisions were challenged, and by the Swiss Ribbons judgment the issues were settled and dust was settled. The power of resolution professional as against the liquidator. It was also clarified that RP is only facilitator, whereas liquidator is having a bigger role than just being a facilitator. As we know, in case of adjudication of the claims also, the role of RP is just to collate, whereas he has no power with regard to adjudication, whereas liquidator has the power to adjudicate, and liquidator does not work under the committee of creditors. RP has been given the administrative power and not the quasi-judicial power. Liquidator, who has the power to determine the claim, has the quasi-judicial power also. So this judgment is very important in terms that anyone who is starting his practice in the insolvency and bankruptcy code, or who has any doubts with regard to the constitutional validity of the provisions of insolvency and bankruptcy code, or who wants to challenge the further any process of the insolvency and bankruptcy code, should read this particular judgment to understand what has already been settled by Honorable Supreme Court before proceeding further for making any challenges, or to have an understanding as to what role these different stakeholders are prescribed to play in the insolvency code. Now, second issue, which was again on the constitutional validity, but came almost after implementation of the provisions of individual insolvency with regard to personal guarantor to corporate debtor. As we know, as we have discussed, that this law is comprehensive and deals with the corporate person insolvency and individual and partnership insolvency also. So whereas the corporate person adjudicating authority has been prescribed in section 60, subsection 1, as a national company law tribunal, the adjudicating authority for individuals and the partnership firms, plain Manila, has been prescribed in section 179 as a debt recovery tribunal. Appeal goes to Debt Recovery Appellate Tribunal and further appeal goes to Supreme Court. Corporate person adjudicating authority is National Company Law Tribunal. Appeal goes to National Company Law Appellate Tribunal and further appeal goes to Honorable Supreme Court. Now, this law is beautifully crafted that it is divided into 5 parts, and each part takes care of one particular segment. Like part 2 deals with the corporate insolvency. Part 3 deals with the individual insolvency. Similarly, part 1 and part 4 and 5 are other. One is definition section, the other one is miscellaneous section, and 4.1 is the authorities like IBBI and other, right? So when the individual insolvency provisions with regard to PG to CD provisions were notified, that is part 3 was notified, the questions with regard to the constitutional validity of this notification with regard to implementation of PG to CD provision only with regard to, the implementation of individual insolvency and bankruptcy provision limited to PG to CD cases. The notification was challenged. The constitutional validity of that very notification was challenged because if we have to understand this background, then we must understand the genesis. The genesis is that why it was challenged, because there is a provision, section 2E of the Insolvency and Bankruptcy Code. 2E deals with the application of Insolvency and Bankruptcy Code to different entities. 2 provides that the provisions of Insolvency and Bankruptcy Code shall apply to, there are different category, corporate person, that is company, that is limited liability partnership, and so on. Then on E, it was prescribing a partnership firm and a proprietorship firm and the individual. Partnership firm, proprietorship firm, and individual. It was mentioned in 2E. However, this 2E was not notified when on 1st of December 2016, the law was notified. This provision got notified later after doing the amendment in 2E. And 2E was replaced to bifurcate into 3 categories. So now there was 2E, 2F, 2G. And E was talking about the personal guarantor to the corporate debtor, a new category, and partnership firm and the proprietorship firm in a second category, and third category was individuals and other persons who are referred to in clause E in relation to their insolvency, their liquidation, their voluntary liquidation, or bankruptcy, as the case may be. Now, this was a change which was done prior to implementation of PG to CD cases. While we read 2E, we must also understand what is the charging provision with regard to notification. Section 1, clause 3 of the Insolvency and Bankruptcy empowers the government to notify the provision. Now 1 clause 3 says that it shall come into force on such date as the central government may by notification in the official gazette appoint, and different date may be prescribed for notification of a different provision. That is the standard provision. That is what we have seen in the Companies Act also. So government was having a enablement that they can choose that whether 2E will be enforced or 2A will be enforced or 2B will be enforced. So government may choose that 2A will come into force, 2B will come into force, 2C will come into force, 2D will come into force with effect from 1/12/2016, whereas 2E will not come into force. So that is the background. That is the enablement that they have done in the, which is there in the any law. I'm just reading so we understand the basics of interpretations also. Now, section 179, which prescribes the adjudicating authority for individual and partnership, which says that subject to provisions of section 60, and 60 deals with the adjudicating authority for corporate person and others. We will read that also. The adjudicating authority in relation to insolvency matters of individual and the firm shall be debt recovery tribunal, having the territorial jurisdiction where the individual debtor actually and voluntarily resides or carries on the business or personally works for gain and can entertain an application. So that means DRT concerned jurisdiction, DRT was the adjudicating authority. And similarly, appeal can go to debt recovery appellate tribunal and further appeal can go to Supreme Court. Now let us see how section 61 and subsection 2 reads. It says that the adjudicating authority for the corporate person, adjudicating authority in relation to insolvency resolution and liquidation for a corporate person, including corporate debtors and personal guarantor thereof, shall be the National Company Law Tribunal, having territorial jurisdiction over place where the registered office of the corporate person is located. Now 60 clause 2 goes on to provide that adjudicating authority in relation to the individual insolvency, that is PG to CD cases, where corporate insolvency resolution process has been commenced or the liquidation process is ongoing, shall be National Company Law Tribunal. So these 2 and 179 are relevant provision with regard to understanding the jurisdiction. However, when the matters were discussed before the adjudicating authority, these were challenged. And the key issues on which the challenge was made was primarily whether the notification that was issued with regard to commencement of primarily part 3 of the Insolvency and Bankruptcy Code with regard to individual insolvency and bankruptcy in context of PG to CD, because notification was limited only for PG to CD. The other individual insolvency provisions have not yet been notified. So part 3 was notified, but it was notified only with regard to PG to CD cases. So this was the essence question. If a government has a power to create a carve out for PG to CD and notify the same without notifying individual insolvency for the other cases, for which the jurisdiction was, the adjudicating authority was debt recovery tribunal, was constitutional or not? That was the question. Second question was the liability of personal guarantor to the corporate debtor in terms of the provisions of Insolvency and Bankruptcy Code. whether this liability is coextensive, or what will happen in the cases where resolution has been approved, part money has been recovered, part money has not been recovered, whether committee of creditors can waive off the remaining liability of a personal guarantor. All these questions were subjected to challenge. Also, question was raised with regard to the liability of a personal guarantor to the corporate debtor in case resolution plan is approved. So these were some 3-4 issues which were parked for validity check in the matter of Lalit Kumar Jain versus Union of India. In 2021, the Apex Court upheld the impugned notification to be valid. The notification by which the provisions of Part 3 with regard to PG to CD were notified. They said, yes, government has the power, and in the framework of insolvency and bankruptcy, government has rightly done so. The court observed that the impugned notification is not an instance of excessive legislative exercise, since there is no compulsion in the court for it to be applicable in its entirety to all individuals at the same time. That is what the issue I was discussing. The essence question was that whether government in its own wisdom can decide whether the Part 3 can be implemented, notified only with regard to one particular set of people, that is PG to CD. For the other classes, it is still not notified whether the government has the power. So Supreme Court said, in the frame of Insolvency and Bankruptcy Code, where Section 2 Clause E got amended, 1 Clause 3 has the specific power to notify the particular provision, and different dates may be prescribed for notifying. The government has all right with regard to doing so, and this act will not be considered as ultra vires. This is well within the powers of the government. Second issue that was settled, that any involuntary act. Involuntary act means, voluntary act means that by virtue of my own consent, by virtue of my own willingness, I have entered into an settlement. So by settlement with the bank, let us assume a case where ABC Limited has taken a loan of rupees 100 crore from State Bank of India. And Mr. A, who is the promoter director, has given his personal guarantee. ABC Limited has defaulted. Now ABC Limited submits a OTS proposal to the State Bank of India. And State Bank of India agrees for 80% haircut. And Mr. A, who is a personal guarantor also in this matter, deposits 20 crore rupees in the bank and executes the one-time settlement. This is a voluntary act of settlement. This is not involuntary, because this is the consensual agreement by which the liability has been waived off. As against this, the involuntary act is that the position has been imposed, that maybe by initiating the SARFACI, maybe by initiating the CIRP or any other legal process. The liability is curtailed down, maybe in a resolution plan. In the same example, where ABC Limited has undergone a CIRP process. Now, ABC Limited has paid in CIRP, or the resolution applicant has paid or agreed to pay 50% of liability. 50% still remains. So can the liability of personal guarantor be said to be waived off? Because once the resolution plan is agreed, once the resolution applicant has agreed to pay 50% of the debt, and the financial creditor has accepted the proposal to which the ABC Limited was not in a voluntary participation, or Mr. A was not in a voluntary participation, whether such act can absolve the liability? Answer was no. And this was settled in the Maharashtra State Electricity Board also, that the liability of the guarantor was in case where the liability of a principal debtor was discharged under the insolvency or company law was to be considered. It was held that in view of unequivocal guarantee, such liability of a guarantor continues and the creditor realize the same from the guarantor in view of section 128 of the Contract Act, and there is no discharge under section 134 of the Act. In this matter, the apex court also held that the resolution plan does not ipso facto discharge a personal guarantor of the corporate debtor of her or his liabilities under the contract of guarantee. The sanction of a resolution plan and finality imparted to it by section 31 does not per se operate as a discharge of the guarantor's liability. That the release or discharge of a principal borrower from the debt owed by to its creditor by an involuntary process, that is operation of law, or due to liquidation or insolvency proceeding, will not absolve the guarantor for his liability, which arises out of the separate contract. So the validity of notification was upheld, and this was also settled that the guarantor will continue to be liable and the petition was were set aside and notification was held to be valid. Another important matter which got decided.
Sir, can I just small two doubts, sir?
Yeah, please.
In case of personal guarantee, just explain us on two issues. One, if the main claim becomes time barred, will it be a voluntary act or involuntary act? One item. Second, in case of when you say it's an involuntary act, it is COC approved, then recommended to the NCLT. So is it not a voluntary act on the part of the COC to agree for a lesser item?
So I'll take one by one. So in first issue, what I am able to understand from the point what you have mentioned, that if a principal debt, that is in the same example what I have quoted, ABC Limited, the debt of ABC Limited itself become a time barred. Now question is whether a PG to CD, that is a guarantee, can be invoked and the individual insolvency can be initiated or not. Is that right, Mr. Ravi?
Yes, sir. That is correct. That is correct.
So point is that we have to see it from two perspectives. One perspective is that whether the guarantee that was invoked, whether I have taken, let us say ABC Limited, the debt was becoming time barred in 2022. And bank has not initiated any action and debt became time barred. However, in 2021, the guarantee was invoked by the State Bank of India. So your right to initiate the individual insolvency against that Mr. A will still be alive, because your 3-year time or the limitation will start from the date of invocation of guarantee. That is, limitation period will start from the invocation of guarantee. That is the date of default after thereafter. Not so there may be two different timelines. There may be two different limitation period which may run parallelly. One against the corporate debtor and one against the guarantor. Not necessary that both will coincide in all cases. May not coincide. Maybe the State Bank of India has required the money from the ABC Limited, but so far has not required the money from the guarantor. Maybe the money is required from the guarantor later. Had it been a case that guarantee was invoked in 2018 itself or 2019 itself, and 3-year timeline has got over in 2022. So in 2023, unless you have a ground for which you can seek the extension of limitation, you will not be considered as having option to initiate the individual insolvency.
Sir, may I ask you a question, sir?
Yeah, please.
Sir, the liability of corporate debtor and the guarantor, they're coextensive. So, first of all, when the account becomes default, then from that date, 3 years is 3 years needed. For the debt to become time bound against the personal guarantor. Suppose the after
Come again.
Sir, let me complete. Sir, let me complete. Suppose on 31st March 2015, account became NPA, and action was taken against the corporate debtor. Suppose 2017 or 18, before 3 years, action taken for initiation of CRP. But no action was taken for initiation of CRP. Now in 2020, can the financial creditor go against the guarantors for initiation of that PG to CD CRP?
So, Mr. Jaina, important point as I understand, now I'll stand corrected if anybody has got a different view. My view is that the limitation period for PG to CD cases will start from the default in honoring the guarantee, right? First of all, the guarantee has to be invoked and default has to happen. If a guarantee is not invoked, so there will be a timeline for invocation of a guarantee also as per Contract Act 124 to 147 of the Indian Contract Act. So if a guarantee is invoked in time, number one, after invocation of a guarantee, the limitation period of 3 years if over, then nothing left.
Sir, let me explain. Sir, let me explain, sir. Sir, suppose 2008 loan was given. In 2015, 31st March, account became NPA.
All right.
Till 2008 to 2015, there is no need to invoke guarantee. But when the account became NPA on 31st March 2015, from that date, within 3 years, this personal guarantee must be invoked. If it is not invoked, so after 31st March 2018, this will become time bound against the guarantors. That is my point, and that is held by NCLT Kotak bench here, sir. That I am telling, sir.
No, I am also saying the same thing. That is what I am saying. We are on the same page. You are saying that guarantee has to be invoked, and unless the guarantee is invoked, so when the insolvency will be triggered against the individual, it is only after invocation of a guarantee. So your guarantee should, there are two timelines which are running. One, for invocation of a guarantee, there is a timeline. Second timeline is after invocation of a guarantee, when you can initiate and trigger the PG to CD, that is individual insolvency.
That exactly I'm telling, sir. Till invocation of guarantee against the personal guarantor, till that day, both the time limitation, that limitation goes hand in hand for both the corporate debtor and the personal guarantor. Once it is invoked, then it is separated. Suppose 2015, 31st March to 2015.
Okay, understood. Now understood. So there is a difference. I'll park this issue because you are saying, I am saying the invocation, you are saying ki timeline for invocation of a guarantee for a PG to CD cases and the default of a corporate debtor runs parallelly, runs same
parallelly till it is invoked against the personal guarantor. Once it is invoked against the personal guarantor, then the 3 years time, the limitation period become different. That will run differently.
I have to examine because
for example, I am giving one example, sir. I am giving one example. 31st March 2015, corporate debtor account became NPA. That is defaulted. So within that 3 years, company has to take action against the corporate debtor. But in 2017, personal guarantor against the personal guarantor guarantee invoked. So against the personal guarantor, again the limitation period will run up to 2020.
So understood. So you are saying ki your time period for invoking a guarantee essentially starts from the default, that is declaration of account as NPA by the financial creditor.
Yes.
From there, the timeline will start. That is the only point that you are making as a condition, right?
Yes.
Which I agree.
That one point. Another point I want to ask you, sir. Suppose the account became NPA 31st March 2015 and the CRP commenced on say 31st March 2017. Then till now, the financial creditor has not invoked that personal guarantee. But CRP started on 31st March 2017 within after 2 years. Then what happened? The CRP process, that CRP, it took, so let us say 1 year or 2 years. Then company goes to liquidation. It takes another 2 years, 4 years it took. But both the IRP and the liquidator, they have acknowledged my debt. Now, in 2021, when the company goes to liquidation and liquidation completed in 2022, after getting the amount from the liquidator, whatever may be, I got, after getting that amount, I invoked the personal guarantee in 2022. Now, my point is, whether this is time bound or within the time limit against the personal guarantor, because account became NPA in 2015. In 2017, CRP initiated. Now, after 5 years, I am taking. Now, court says, tribunal says, you establish the limitation. So, in my point, limitation continues because in 2017 it goes into CRP. 2017 RP acknowledged the debt when I lodged the claim in Form C. Acknowledged the debt, and in 2021 again it is acknowledged by the liquidator. So my point is that then tribunal asks whether RP and liquidator are agent to acknowledge the debt under Section 18 of Limitation Act. Sir, I want your view on this.
So my
because
view
if they are not agent of the corporate debtor, so their acknowledgement will not be treated as an acknowledgement under Section 18 of Limitation Act.
So I will just give my prima facie view. I have a very detailed discussion on the law of limitation parallelly, separately in the coming discussion itself. So we will discuss law of limitation also, and therein we will cover. But my view, as far as your question with regard to this extension of timeline is concerned, my personal opinion in this matter is, which is supported perhaps by a couple of NCLT rulings also, is that the limitation will expire, which will not continue to be extended. The insolvency professional or resolution professional giving the acknowledgement of debt with regard to this particular subject will not be considered as agent. Giving a extension is in the Section 18 of the Limitation Act.
But sir, in 1986, Supreme Court order is there. as per Supreme Court order, that is 1986, whether this will apply to this IPC or not, that's why I'm asking. Supreme Court order, that for the purpose of liquidation, liquidator, that official liquidator, at that point of time, official liquidator is treated as agent for all purposes. So if liquidator is treated as a 1986 Supreme Court order is there, at present that is not in front of me. Supreme Court order is there. Official liquidator is the agent for all purposes for the company.
So I think
so why that will not extend here also?
Mr. Jaina, we have to, I think there are two issues. One, we are not talking about in this matter for ABC Limited. Had this been a case of ABC Limited, right, then the issue was different. Here we are talking about a guarantor of ABC Limited. Whether this time limit, whatever we are talking about, will extend for ABC Limited, answer is different. Whether it will extend for guarantor of ABC Limited, answer is different, right? So my view is that if I am talking about the second situation, that is guarantor of ABC Limited, it should not extend. I'll give you the reasons also. I'm parking this particular point for discussion because limitation is a detailed subject and we have parked that issue for deliberation. There are almost 10 judgments on limitation subject itself. We will discuss that threadbarely. Let us move.
One more point, sir. One more point.
Yeah,
sir, can the resolution applicant put a clause in the resolution plan that on implementation of resolution plan, the personal guarantees are extinguished?
Very recently, the judgment is there and they have declared that no resolution plan, no committee of creditor is empowered to pass such kind of resolution or to approve such kind of resolution plan. You cannot extinguish the third party. You cannot extinguish the obligation of a third party. That is what the judgment is talking about. We see how it takes shape, but so far the position, I think very recently only, not more than a month or 2 month old judgment, wherein it has been very categorically stated. Prior to that, yes, there have been, I am also privy and you must also be privy to a couple of resolution plans where the committee of creditor has extinguished the liability of personal guarantor in certain matters and that has not been challenged. But I think in this particular matter, that was observation by the adjudicating authority, and that has been upheld by the appellate court also. So that is my view. And if possible, I'll share you the ruling and judgment also. I think I am having this copy in this compilation itself. Another issue which came was in the matter of Mr. Maitreya Doshi versus Anand Rathi Global Finance Limited and others. That judgment is very recent on 22nd of September 2022. The essence was that if a approval of a resolution plan in respect of any one of the borrower can discharge the co-borrowers, something very similar to what Mr. Jaina was asking, though the issue is little different. In this matter, what happened, Anand Rathi, which was a non-banking finance company, disbursed a loan of 6 crore to one company called Premier Limited. And 3 separate loan cum pledge agreement on 3 different dates were executed. And there was another entity, Doshi Holdings, which was holding shares of Premier, pledged their shares in favor of Anand Rathi. Now, loan cum pledge agreement contemplated 2 distinct transactions in one document. One for grant of loan to Premier and creation of pledge by Doshi Holdings of securities held by Doshi Holdings in the Premier. So these are two transactions which occurred. Of course, default was there. and matter went into CIRP. CIRP was filed by the financial creditor under section 7 for IBC 7 of IBC against the Premier Limited as well as Doshi Holding. Both petitions were heard together, and adjudicating authority admitted the petitions against both of these companies simultaneously. And when the appeal was filed, NCLAT dismissed the appeal and upheld the order of admission against both of these entities. Further appeal was filed to the Supreme Court, and Supreme Court noted that the appellate authority arrived at a factual finding that Doshi Holding was also a borrower under loan cum pledge agreement. Therefore, the CIRP can continue against the Doshi Holdings also. Court also held that if there are two borrowers, or if two corporate body falls in the ambit of corporate debtor, there is no reason why proceeding under section 7 of IB code cannot be initiated against both of these corporate debtor at the same time. The same amount cannot be realized from both corporate debtor. Of course, if you have a outstanding of 100 crore, you can receive 100 crore or in one part. You cannot receive 200 crore against the outstanding of 100 crore. That care has to be taken. That's what the Supreme Court mentioned. And in this matter, Supreme Court also referred the previous ruling in the matter of Lalit Kumar Jain versus Union of India, that once on the approval of the resolution plan in relation to the corporate debtor, there is no discharge of the guarantor. On the same line, the matter was decided. There is another important ruling, which is again of 6th of September 2022. That is...
Sir, ultimately in that Metro Doshi won, na? And Anandrati lost, I think. I don't remember the fact exactly right now.
No, it was opposite, na? See.
No, I think Anandrati lost in that case. I don't remember often, but whatever I had read last, I think 6 months back, when the September.
We can check that again, once again, because this updation I had done up till Supreme Court ruling itself, and this judgment I think has attained the finality, which was on September 22nd of September. This is Supreme Court order only, and Supreme Court, see, NCLT admitted both of the application. Appeal went to the other entity. Doshi went to appeal to NCLAT against the admission order of NCLT. And because NCLAT upheld the judgment of NCLT, the Doshi went again to Supreme Court in appeal under 62. And Supreme Court again mentioned that the order of NCLT and NCLAT are upheld, as far as I remember, but I have a copy.
Okay. I will check during the lunchtime and then we'll discuss again. So
yeah,
we need not.
Yeah, correct. So another matter which was again on the very similar line, that was in the matter of K. Parmasivam and the Karur Vyas Bank, and the matter was decided somewhere on the same time on 6th of September 2022. Where it was decided that the financial creditor can proceed against the guarantor without first suing the principal borrower. That is, I can proceed the guarantor without initiating a process against the principal borrower. And this is a very landmark judgment, if I can quote so. The matter is relating to Maharaja Theme Parks and Resort, which was a company which was incorporated under 56 Act, Karur Vyas Bank extended the credit facilities to 3 entities. One was Maharaja Refinery, Maharaja Industry, and Maharaja Enterprises. Now, in this matter, Maharaja Theme Park became a guarantor for these loans, and the borrower failed to repay the debt to the financial creditor. That by the Karur Vyas Bank initiated the application under Section 7 of IB Code before the NCLT Chennai. And the application was filed against the guarantor. Maharaja Theme Park was guarantor for all the 3 credit facilities extended to Maharaja Refinery, Maharaja Industry, and Maharaja Enterprises. And no process was initiated against these 3 entities. Maharaja Theme Park and Resort objected to the contention of the financial creditor and argued that they do not fall within the purview of the corporate debtor, as defined in Section 3, Clause 8 of the Insolvency and Bankruptcy Code. Now, what is 3, Clause 8? If I can just share the other screen. Now, corporate debtor means a corporate person who owes a debt to any person. Now, if I make a very restrictive interpretation of the term corporate debtor to mean the person who owes a debt to any person, it looks like prima facie only the person who is a principal borrower will fall into the category of a corporate debtor. Now, Supreme Court interpreted the provisions of 3 Clause 8 liberally and stated the person who is a guarantor, he also steps into the shoes of a corporate debtor because he also owes a debt to a person. So, in this matter, Maharaja Theme Park was also a corporate debtor because he was also owing a money to the Karur Vyas Bank. In this matter, Maharaja Theme Park contended that they are not corporate debtor, corporate guarantor also, according to Clause 5A of the Insolvency and Bankruptcy Code, because the borrowers are not corporate debtors. Because these were non-corporate entities, so his contention was that, however, adjudicating authority did not pay any heed to the same and the matter was admitted. Appeal was filed before the Appellate Court. Appellate Court upheld the order of NCLT. An appeal was filed further to the Supreme Court. Now, Supreme Court was vested with one issue: whether the liability of a corporate guarantor is coextensive with that of a principal borrower, whether Maharaja Theme Park is a corporate guarantor as mentioned under 5 Clause 5A of the Insolvency and Bankruptcy Code. So the issue primarily relates because the entities who have borrowed the money, they were not corporate, number one. So whether the person who has given a guarantee will fall into the definition of a corporate debtor, A. Whether this person will fall into the definition of a corporate guarantor because the money has not been given for securing the borrowing of a corporate person, but the person to whom the money has been given is a non-corporate person. That was a background, and in that background, what Supreme Court has done the analysis while upholding the judgment of NCLT and NCLAT, they stated that in the matter of Lakshmi Pat Surana versus Union of India, this is a landmark judgment in this particular regard, where they have stated that the financial creditor has a cause of action to proceed against the principal borrower as well as the guarantor in equal measure in cases of default. And bench referred to section 5 clause 8(1) Roman 1 of IB code, which stated that the claim of the financial creditor also include liability of person who gave the guarantee to the corporate debtor. If we can see 5 clause 8, clause 8, any amount, I hope you are able to see the PDF. The amount of liability in respect of any guarantee or indemnity for any of the items referred to in clause A to H. And A to H is talking about any money borrowed is a clause A. And this is a definition of a financial debt. So by applying this principle, that if this covers specifically in terms of clause 5(8)(I), then why the person will not be considered as a financial creditor? And it was also mentioned that if you see the provisions of section 128 of the Indian Contract Act and the position of 3 clause 8 and the definition of corporate person in 3 clause 7, that will also get extended and it will include these peoples also into the figure. Similarly, the other judgments of Lalit Mishra and Sharon Biomedicines are also on the same lines, and those were also referred into the judgment. But essentially, the judgment was based on the landmark ruling in the matter of Lakshmi Pat Surana. One more matter I think I'll take in this particular regard, which is Mahendra Kumar Jajodia versus State Bank of India, where Supreme Court dismissed the appeal against the NCLAT order on initiation of insolvency proceeding under section 95 of IB code, even when no proceedings are pending against the corporate debtor before the NCLT. Now, this is a sweeping judgment, I will say, because this matter has been adjudicated, at least I am aware about 50 odd matters which have been decided by different adjudicating authority. There may be more, 50 I am saying on the lower side, but maybe more, where similar issue has been raised and the matter has been differently decided by various adjudicating authority and has been controverted before the appellate court also. Now, after arriving a finality by the Supreme Court, the essence is that 60 clause 2, the basis of understanding, the basic of understanding when the PG to CD cases were invoked or the provisions were notified, was that presently only those cases PG to CD will be invoked where CIRP or liquidation is ongoing. Where CIRP or liquidation is not ongoing, the proceeding cannot be invoked because the adjudicating authority for the same will be Debt Recovery Tribunal. This was an understanding. I'll be very honest in admitting that this was an understanding which I was carrying until reading this particular judgment. And I'm still not very convinced with the arguments which had been advanced in this particular matter, because if we read specifically the provisions of section 179 and section 60 clause 1 and 2, I still hold a different view, but order of Honorable Supreme Court is already there. So we have to read in between the lines to understand as to what has transpired the Supreme Court to give such kind of verdict. What happened, the matter was very clear that the State Bank of India, invoking the provisions of section 95, which gives a power to a financial creditor to invoke a individual insolvency against the PG to CD, against the individual basically. PG to CD is a corollary which is coming from 2E of Insolvency and Bankruptcy Code. This was a matter relating to Calcutta bench, and Calcutta bench rejected the application as being premature. Why premature? Because as was my understanding that your PG to CD application can be admitted only in those cases where CIRP or liquidation is ongoing. Where there is no CIRP, no liquidation, the application cannot be maintained before the NCLT. Of course, you can maintain the application, but that application would be maintained before the Debt Recovery Tribunal, not before the NCLT. And because Debt Recovery Tribunal provisions are not yet notified, so the application will not be maintainable. That was the view the NCLT has given in this matter. Now, appeal was made to NCLAT, and NCLAT allowed that appeal and drew the attention of NCLT to two provisions, 60 clause 1, which states that the adjudicating authority for the CIRP or the liquidation of a corporate person, including corporate debtor and personal guarantor, is National Company Law Tribunal. Now, these are very, very catchy lines, which catchy terms, which gives rise to perhaps this particular judgment also, especially the bracketed portion, that the corporate person, including corporate debtor and personal guarantor. Corporate debtor and personal guarantor is a key word in this 60 clause 1, on which this order of NCLAT is based on. Because NCLT was hammering on 60 clause 2. 60 clause 2 states that without prejudice to the subsection 1 and notwithstanding anything to the contrary contained in this code, where CIRP or liquidation proceeding against a company is pending before the NCLT, then the application for insolvency resolution, liquidation, bankruptcy of a corporate guarantor, personal guarantor of such corporate debtor is to be filed before such NCLT. So this is the second situation which is known to by and large to everybody. So when CIRP liquidation is on, jurisdiction will be NCLT. This is known to everybody. But what is less known as to how to interpret the term corporate person, including corporate debtor and personal guarantor, I think is flowing from this ruling of NCLAT and then by Supreme Court. So court observed that there is a distinction between 60 clause 1 and 60 clause 2. 60 clause 2 contemplates a situation where the proceedings against the corporate debtors are pending and stipulates that an application against the guarantor is to be filed with the same adjudicating authority. If proceeding is not pending, then section 60 clause 1 will apply. The forum is still NCLT, but the one having territorial jurisdiction over the place where the registered office of the corporate person is located. So this is a difference, because 60 clause 2 application goes to the jurisdiction where the corporate debtor registered office is situated. That is where maybe I am residing somewhere else. I am residing in Lucknow and corporate debtor is, let us say, in Delhi. So my jurisdiction in clause 61, if I fall in 60 clause 1, is Lucknow, that is Allahabad. And if I go for 60 clause 2, my jurisdiction will be Delhi. That is the difference between 60 clause 1 and 2, what the adjudicating appellate authority has maintained. Whereas my view, when I was reading 60 clause 1, although I could not interpret the provisions with regard to the last part, that is the personal guarantor. What is the intention of including the personal guarantor? Though it is not saying the personal guarantor to the corporate debtor, but we understand it is in the same context. So that ruling is going to be landmark in the sense that up till now the clouds over the commencement of individual insolvency standalone have been shredded, and the cases which were in dilemma whether to initiate the individual insolvency or not, this ruling has paved the way, and I can expect many more cases, unless barred by limitation, as Mr. Jaina and we were discussing, and we will discuss further also in the limitation. These matters will be increasing, I think, manifold in times to come. Another interesting matter, which is regarding the non-obstante provision in section 238. So 238, we know, which is reading that notwithstanding anything contained in any other law for the time being in force, the provisions of this code shall have overriding effect. This matter has been settled way back in the Supreme Court by Principal Commissioner of Income Tax versus Monet Ispat, very celebrated judgment on 10th of August 2018, and will wherein it was held that the income tax dues, which are in the nature of crown debt, will not take precedence over the secured creditor. So section 238 gives that power, and because section 53 also starts with non-obstante clause. So there are two non-obstante clause which gives a force to the ruling what Principal Commissioner of Income Tax versus Monet Ispat.
Sir, one small doubt, sir.
Yeah.
Small doubt. In the previous thing, jurisdiction where CRP is not initiated.
Yeah.
We thought it is with DRT. So if the CRP is not initiated, we thought it was DRT. Then once the CRP gets initiated, the file should be transferred to NCLT. That's what I was under the impression. Am I wrong? Or?
Raviji, I was also, you are talking about 60 clause 2.
Right, sir.
Yeah, but I believe there are two parts to it. Let me just open 60 clause 2 also. So I believe now you'll be in a position to see that. Let me just.
I understood, sir, because if we don't initiate.
I have understood the point.
So
that
if the CRP is not initiated, personal guarantee can be invoked. Okay. Now the forum should be DRT if the CRP is not initiated, and as and when the CRP is initiated, the file will be transferred from DRT to NCLT.
Now this is 60 clause 2 and 1 both. Now let us read it out how it is worded. Now, what it says, without prejudice to subsection 1 and notwithstanding anything to the contrary contained in the code, where CIRP or liquidation proceedings of a corporate debtor is pending before the National Company Law Tribunal, an application relating to the individual insolvency or liquidation or bankruptcy of a corporate guarantor or personal guarantor, as the case may be, of such corporate debtor shall be filed before National Company Law
So
Tribunal.
this speaks of a case where there is a case pending in CR.
Where there is a case that is pending. Absolutely.
Right.
So that is what.
No, that is true. But when we are talking of a case where there is no case pending.
So that is 3.
Okay.
That is 3, where it says insolvency resolution process or liquidation or bankruptcy proceeding of a corporate debtor of personal guarantor, as the case may be of a corporate debtor, pending in any court or tribunal shall stand transferred to adjudicating authority dealing with the insolvency resolution process or liquidation process of such corporate debtor.
Right. So here tribunal means DRT.
Yeah, absolutely. Suppose, let us take a situation that Amit Gupta resides in Lucknow, and presuming that individual insolvency provisions are also in force, right? And the application has been initiated before DRT, right? DRT, Lucknow. So tomorrow, if a proceeding against the corporate debtor of whom I am a guarantor is initiated, let us say that is initiated before Delhi, then this application from DRT Lucknow will be shifted to NCLT New Delhi. That is the 3.
Right.
I am trying to distinguish between 1 and 2 also. Now 1 and 2 is saying, one is saying that I'll initiate the insolvency process in the territorial jurisdiction over a place where registered office of the corporate person is
That's
located.
a general statement. That is general statement. So that's it.
Correct, correct. Now, if I have to initiate the personal guarantee, that will be governed by section 179, 179(1). Now, if I am not triggered with the, if I am not triggered with the PG to CD case, right? In those cases, 179 will be the charging provision, and 179 has a similar provision where the location of my location, that is Amit Gupta location, will be relevant for the purpose. 179 says, subject to provisions of section 60, the adjudicating authority in relation to insolvency matters of individual and firm shall be debt recovery tribunal, having a territorial jurisdiction over the place where the individual debtor actually and voluntarily resides or carries on the business or personally works for gain, and can entertain an application under this code regarding such person. So this is the place where the application, if standalone, is filed against Amit Gupta, will be Lucknow. As per 3, tomorrow if CIRP is initiated where I am a guarantor, then this application will be transferred to that very jurisdiction, that is 3. Now, other situation, that if CIRP is already on, then it will be initiated in Delhi. And the first case which we were talking will be in Lucknow. I hope I'm not confused.
That's clear. That's clear. I am very clear in this. If you are a personal guarantor and there is no CD initiation, it will be in Lucknow.
Correct.
As and when the initiation happens against the CD, the file will be transferred to Delhi.
Correct. But you are having a consensus with the Honorable Supreme Court, where it says that even the CIRP or liquidation is not in process, the individual insolvency can be invoked and the jurisdiction will be NCLT.
No, it only says it can be invoked. Does the Supreme Court judgment say that it will be NCLT? Jurisdiction also does it? Even
for that matter, because jurisdiction is guided by section 60.
Or right? 179(1.
179(1), whatever the case may be. Now, because 179 cannot be the case because DRT is not in force. 179 to the extent that it is applicable for standalone individual cases, still it is not notified. So that cannot be a case, right?
No, sir, for even for personal guarantee cases, we are actually going through the sections of this 179 and all that part. Then now the personal guarantee provisions of the IBC only we are following. No.
No, but are you invoking
So what I'm saying is that whether invoking or not, when say personal guarantee is invoked, the provisions applicable are only that of the individual insolvency we are following. No?
So Ravi sir, point is that that we will be able to invoke only when 179 standalone for individual is in force. My limited point that I'm saying, 179 to my understanding is not in force in the sense that DRTs have so far not been given the power to take up the cases, right? So
yes.
how
So
can
in Bangalore actually, we have filed certain cases in DRT only.
I am aware
the personal guarantee.
I am aware that many of the DRTs have even passed the orders also. My question is only fundamental, whether those actions are legitimate, whether those actions will survive as far as the test of applicability and the legality is concerned. My limited point is that only. So my view is still is that I don't know how many of us will agree to this, but I'm just putting forward a point which may be considered by the learned members also, that Supreme Court order where it says that you can initiate the individual insolvency against a guarantor in those cases where CD action has not been initiated yet or is not pending even. There are contrary judgment in respect of whether the application, where the application is pending. That's a different story. I'm not going into that. But essence is that CD action is not initiated or pending, whether those matters can legally be invoked. If yes, then what will be the forum? I think Ravi sir is saying that the forum would be DRT. My question is whether DRT is having a power to look into such cases as of now is a question that I'm parking.
Right. So what I was saying is that for even though the personal guarantee is invoked, or okay, once personal guarantee individual is comes into the picture, the provisions we are reading are only that of the individual insolvency. So automatically the entire individual insolvency thing will come up because we don't have any special provision for a personal guarantor provisions. Then we don't have individual insolvency provisions. No?
I'm with you. My only difficulty is that I agree, we will reach to 179. Now, if 179 has to be in force so that the matter can be filed before the DRT. Otherwise, DRT will not be able to take up the matter because 179(2) gives the power to adjudicating authority to proceed with the matter. From where that power will come? If you see 179 further, that says 179 to the debt recovery tribunal shall, notwithstanding anything contained in any other law, have jurisdiction to entertain and dispose of. So from where, unless and until this provision is notified for PG to CD, how come this provision will be invoked is a doubt that I'm having. Maybe I'll stand corrected, but that is the point that I'm still struggling in reconciling myself.
Okay, sir.
So we were on non-obstante provision of section 238. We were talking about 53 non-obstante vis-a-vis 238. So having said all, I think there are plethora of cases, but I have taken a couple of celebrated judgments. Very recent one where Rainbow Paper, which was decided on 6th of September 2022. 6th of September.
Amit, may I interrupt?
Yeah, please, sir.
Amit, I was reading somewhere that now, the income tax, dues liability will continue even after the approval of the resolution plan.
I'm coming to that only. So this is
Okay. I was reading somewhere that now they have allowed, I think it's, yeah.
You're right. It has given rise to a lot of controversy.
Yeah.
Controversy has arisen from the judgment of Rainbow Papers. That is what we are going to discuss and deliberate now. We know what is the waterfall mechanism. Waterfall mechanism is a mechanism provided for distribution of liquidation proceeds in a situation of liquidation. Distribution of the way the distribution of liquidation state will take place amongst various stakeholders. Why it is called waterfall? Because if you assume that you are sitting on a slanted surface and the slanted surface has got some 8 holes. The water, if is dropped from the top of the slanted surface, the water has a tendency to go and fill the first hole first. If water remains, it will come to the second hole, then third hole, then fourth hole. Last hole will get the water only if the previous 7 holes are filled. That is the waterfall. So that is why the 53 distribution is called water flow, because the tendency in which the distribution will take place is also replica of the same. That is, if money is sufficient, which is sufficient only for CIRP cost and the liquidation cost, the money will not go to workers. If money is sufficient to meet the requirement of workers and the secured creditor, it will not go to the third layer, that is employee dues for the last 12 months. If money is sufficient only up to this, then unsecured creditor will not get the money. Then likewise, operational creditor will not get the money. Government will not get the money. So this is the order in which the water will fall or the money will flow. Now, if I specifically talk about the Rainbow judgment, in this matter, the Gujarat VAT issue was raised before the adjudicating authority. The state tax officer, who was the appellant, has made the assessment of VAT liability amounting to 53 odd crores, which was payable to the tax authorities. And in pursuance thereof, the appellant, that is the state tax authority, initiated the recovery proceeding and attached certain properties of the company also. That is the entity. Now, there was the entity Neeraj Papers Private Limited, who was operational creditor. He initiated the CIRP against Rainbow Papers. Matter was of NCLT Ahmedabad. Ahmedabad bench admitted the CIRP, and insolvency professional was appointed. And the claim was required to be, as we know, 14 days time is required to be given, and the claim was required to be filed. So appellant also filed their claim to the tune of 47 odd crores. RP informed to the state tax authorities that the entire claim amount of 47.36 crore had been waived off. In pursuance to the same, appellant challenged the resolution plan before the Ahmedabad bench of NCLT. Claim was admitted. Later on, when the resolution plan was submitted, resolution plan did not provide for any payment to the state tax authorities in pursuance to this VAT liability. And further, sales tax officer was a secured creditor within the meaning of the Insolvency and Bankruptcy Code. This view was rejected. appeal was filed before the appellate court. Appeal was also dismissed. That is, the state tax authority lost before the appellate court, and appeal was filed before the Supreme Court. Now, issues which were raised before the Supreme Court, whether the provisions of Insolvency and Bankruptcy Code, and in particular Section 53 thereof overrides Section 48 of GBAT, was a essence question. Now, what was the contention of a state tax authority? Now, state tax authority argued that since recovery proceeding had been initiated against the Rainbow, the books of accounts of the CD would reflect the pending tax payable to the state. The learned Solicitor General had contended that by overlooking its primary role of properly examining such books of accounts of the corporate debtor, RP has failed its duties. The appellant further contended that such a resolution plan was not in tune with the process established under Insolvency and Bankruptcy Code, hence was not binding on the state. Now, appellant further highlighted that meaning of the term secured creditor as defined in insolvency is extensive and broad enough to incorporate all type of security interest, including mortgage, charge, hypothecation, and any other agreement for securing payment for the performance of any duties or obligation therein. The finding of appellate court that Section 3 Clause 30 and 3 Clause 31 of IB Code, the state was not a secured creditor, was erroneous, because appellate court also held that they are not secured creditor. ASG further argued that merely on the basis that appellant was an operational creditor does not translate to not being a secured creditor. Further, the appellant made a claim before the RP long before the resolution plan was approved by the Committee of Creditor, yet RP failed to include the appellant's claim in the resolution plan. It was further argued that Insolvency Code certainly clearly states that Section 31 of the IB Code, the adjudicating authority can approve the resolution plan only after such plan meets the requirement for payment to secured creditor under Section 30 Clause 2, which are the conditions for approval of the resolution plan. Now, what Supreme Court passed as an order? Supreme Court accepted the argument of state tax authority that under Section 48 of the Gujarat VAT, the claim of the tax department of the state would be within the definition of the security interest. This is a very important underlying word. So wherever the respective act provides for having a security interest creation by virtue of provision of respective law, this judgment will have an impact. Now, there are two things which we need to analyze. GST law, which is a law which was enacted after Insolvency and Bankruptcy Code. And GST law also has a non-obstante provision, which talks about notwithstanding anything contained in this any other law. That means when the insolvency law was in force, GST law was enacted, and GST law provided that this will be the secured creditor and the priority payment will be made for the dues of GST. This situation perhaps is not there in respect of income tax law. So where Mr. Khubchandani has flagged that certain income tax matters have also been decided, where it has been stated that income tax dues will also stand on the similar footing to what the GST dues have been in the matter of rainbow paper, I have a difference of opinion. Rainbow paper is specific to GST, and the ratio of the Supreme Court judgment in rainbow paper is applicable only in those specific cases. I have not came across any other law wherein a position similar to GST has been provided, and that is the law which is after insolvency and bankruptcy. Income tax is a law which got enacted in 1961. Though the provision of security interest is very similar to what is there in GST law, but because the GST law is after insolvency and bankruptcy law, perhaps that is the rationale that has been applied in the matter of rainbow papers, and this ruling has become sustainable as far as shattering the priority order of the section 53 is concerned. But in respect of other claims, which are like the other statutory dues, whether the similar position will stand or not, I'm having my own doubts. For the reason I stated, so to answer to the question what Mr. Kupchandani has asked, maybe initially, because whenever the judgment comes, many of the adjudicating authority, because everybody wants to take a benefit of the judgment. So many of the matters have taken the shelter of rainbow paper, and this judgment has been misapplied in many of the matters. I can quote unquote. Maybe over a period of time, this dust will again get settled. And the ratio, the fine reading, as I have been able to make, will create a distinction between this matter and the other matters, and the dues of GST vis-a-vis the dues of the other entities. So GST dues may qualify to the criteria of secured creditor in terms of the non-obstante clause and having a law creation date after insolvency and bankruptcy code. I think these two are the reason primarily due to which I find that judgment will be different. Yeah, Mr.
Sir,
J.
Sir, one second. Will this only be applicable for section 53 in liquidation, or does it also hold ground during the CIRP? Because let's say when the CIRP proceedings start,
Yeah,
and the claims of the GST which are unpaid, even while filing a resolution plan or while approving the resolution plan by the COC and its vetting under 32, whether the dues of GST will, what will be the, how they will be, how the resolution applicant will take that into account?
so view is that you don't have to apply 53 completely while approving a resolution plan. However, now in terms of, there are two things: before the consideration of a discussion paper and after consideration of the discussion paper, what is issued recently by the Insolvency and Bankruptcy Board. If we consider it prior to release of that paper, there are only few matters for which the 53 has a relevance in the resolution plan, which is with regard to the claims of the operational creditor, where this also fits into. So if an operational creditor claim is now going to be secured, then to that extent, it will be considered to be having a change in the priority, and resolution plan will also be required to be accordingly be passing the test of this particular requirement, that they are provided with the amount what they get in the matter of liquidation. That is the requirement under section 30 clause 2 of insolvency. Other than that, I don't see that it will have any much impact, and it will not have any impact in respect of other statutory dues also. Now, after Insolvency and Bankruptcy Board has released the paper and the way it has came up, I think the situation may get a little different when this law will get notified, when this new law will get shape up, and the new law will get into force. I think it will have a different implication, because the 53 application in many other contexts has also been recognized for resolution plans also. So it will have a different implication in those cases.
So, sir,
But
pending
Amit, I
this,
think, sorry,
just
Amit,
one
I
second.
think this judgment is still pending for the review, na, before the Supreme Court.
No.
Can I please come in?
Review is already over. I'll show you the review also. I think I'm not sure whether I have captured.
Sir, just
But
may
it
I
has
ask
not
a question,
established
sir?
the law
Sir,
yet. I
simple.
think NCLT is considering this thing on case-to-case basis.
Yeah, they are considering it on case-to-case basis. That is what I'm saying. We are all interpreting by applying the principles what we are able to read out. So yeah, the matter is still in review. I'm not able to find out any final review order. Nah? But so far, as you rightly mentioned, that different adjudicating authority and different appellate authorities have been in different matters. There are many matters where the income tax dues have also been put to the similar position where what is falling from rainbow matter. There are many matters which have been rejected also. So there is no uniformity which is being followed as of now. So what Mr. Khubchandani has raised, that in certain matters it has been stated that now statutory dues of the income tax authorities will also have the similar treatment as has fallen from the rainbow matter. So, but I believe unless and until it is revisited as mentioned that in review petition, or the law is further settled by way of an clarification or necessary amendment in the Insolvency and Bankruptcy Code, I think this leaves open many of the questions. But one thing is very sure, which I am able to apply, even if this judgment remains as it is, it will have a very less application. The damage is going to be very minimal and will be limited only and only to these particular dues, not in respect of the other dues. That is what my reading is.
Sir, just a question, sir.
Yeah.
Sir, I've got partial answer from your previous reply. But sir, my question is that, sir, if GST is considered as secured operational debt, how will that be treated in case of liquidation? Because that will be overridden by unsecured financial creditors. And in that case, if the secured operational creditor wants to impose its security interest, because they will not go for liquidation, they will prefer to impose their security interest. And my second point is that if they are overridden by unsecured financial creditors, then how their interest will be security interest will be protected in case of resolution by way of resolution plan.
Now you see, you will get the answer by reading 53. What 53 says: the following debt, which shall rank equally among the following: workman dues for the period of 24 months preceding the liquidation commencement date. This is okay. The debt owed to a secured creditor in the event such secured creditor has relinquished the security interest in the manner set out in section 52. Now, D is financial debt owed to unsecured creditor, and then comes E, where it is mentioned that debt owed to a secured creditor for any amount unpaid following the enforcement of security interest. Now, where is the term financial secured creditor is used? There is no distinction between financial secured creditor and operational secured creditor.
Yes,
So
sir,
my view is that the state dues, the statutory dues which are secured, will settle either at layer 2 or will settle at layer 5, depending whether you are relinquishing the security interest or not. But because you don't have anything in your security interest, you don't have any charge, like in case of a financial creditor, you have a mortgage of an asset and you are relinquishing your right or you are enforcing your right, right? So you will be invariably be fitting into this criteria and this parameter only. So that way it is damaging, it is impacting. I hope.
But here, sir, if a operational operational creditor who has created interest by way of any law, then if that operational creditor does not relinquish its interest, then how will they enforce that right?
No, enforcement will take place only, relinquishment will take place when I have a custody. I don't have a custody, I don't have a charge, right? But I have a security interest. So that
Sir,
is
not custody, sir. Charge does not require custody, sir. Even a hypothecation, even an assignment, that is also security. That can be enforced.
Understood. See, enforcement, I believe, in this case was from the context that can you proceed for enforcement without having anything in your position or in your
yes, hypothecation that is not in my possession, mortgage that is not in my possession.
Not possession. I'm using the wrong word. Don't misinterpret that. What I'm saying, the security interest of a GST authority, state tax authority, where he has not created security interest by way of hypothecation, mortgage, or lien.
Yes.
Their security interest is by virtue of provision of law.
Yes.
Right? How can he enforce that? Because he cannot go and invoke the mortgage. He cannot go and invoke the hypothecation. He cannot go and invoke the lien.
That means such secured creditor do not have any right to relinquish to enforce. They have to relinquish. They are bound to relinquish their security interest.
So they will sit
they have a security interest, but they have to relinquish.
So they will sit at layer 2. They will sit at layer 2. That is what is the corollary.
Sir, sir, may take in 1 second.
Yeah. Yeah,
supposing there's a company for which there are 5 lenders. Okay, take an example, Mr. Sirendra, I'm typing. See, suppose there are 5 lenders, and all 5 lenders have a security on the one building, plant and machinery. Now, can any one of them say that I'll go under section 52?
This issue has been
no. Similar is the case with GST also. He is also having security in all the assets of the company, but he can't say that I'll go under section 52 because he is a part of this. He's holding the security along with other lenders. So if you're having only sole security of any particular item, then you can say I'll go under 52 and realize on myself. But you're holding a security on pari passu basis with other lenders, then you can't say that I'll go under 52. You have to compulsorily relinquish and go with the flow under this 53(2)(1)(2) only.
So honestly, I have not applied my mind to what Mr. Ravi has stated, or to the security interest of the state authorities, especially, right? Because this security interest is very interesting. This is flowing only from the, you can say, the judgment of Rainbow Papers. Prior to that, we were aware about that these kind of security interests are created in certain laws, maybe under section 178 of the income tax also, and
Sir, even the Provident Fund Act has this. That's what we are seeing nowadays.
Also has,
they have a preferential payment rights and all that.
Now, whether what will be the process of relinquishment of these security interest, I think has not so far been debated or discussed anywhere in judicial forums. We are also very new to that particular process, and honestly, I have not applied my mind to that.
Here it is very clearly written. Secured creditor has relinquished security interest. That means here the state authorities, they have to relinquish. So only then they will be in B2. Otherwise,
Mr. Jaina, it is not a problem. You will come to me. I am a state tax authority. I'll say I am giving you in writing that I relinquish my interest. I don't want to enforce. You kindly proceed with liquidation. I will take the proceeds as per 53.
And that is exactly my point, that they do not have any option except relinquishing the security interest.
Mr. Jaina,
That is my point.
I am with you. I am only trying to address the point what Mr. Ravi has raised, which is very valid. I don't have any answer to that. I am trying to find out the answer to that as to what will be the methodology adopted for that relinquishment or how the enforcement will take place. Relinquishment is not a problem. How the enforcement of security interest of state authorities will actually take place is $1 million question, which answer exactly. I don't have.
Yes, sir, exactly.
Right. I think authorities will also have to, we also have to apply our mind, but I am not prepared today, at least to give that answer. I'll be very honest, and we may park this.
No, Amit, I think clarity can come only by amendment in the law. There is no other way out.
No, that is all right. But even if because it is not that only GST law has this kind of security interest, which has so far been ignored by many of the professionals in their discussions. Now, because the Rainbow paper has given a thread for reopening this Pandora box of the security interest, we need to understand by these kind of security interests will fall into what category and how these security interests will fall, because you don't have any underlying asset identified for enforcement, right? What you are having in
that's what I'm saying. That's what I'm saying, that this will come only by amendment in the law. There is no other way out.
No, so the amendment in the law is already proposed. That discussion paper is already there, which makes a distinction between security by which has an underlying transaction and securities which are because of operation of law. That's what the discussion paper discussed. Correct. Saying that supposing if they have an underlying transaction means where you have taken a loan or something and created a security. Other things are by operation of law, which are like GST. So that is the amendment that has been proposed now. So when it's backed by a transaction, then it will be covered here. That's what they wanted to say.
No, so that's why I'm saying only statutory dues. As regards those statutory dues is concerned, there will be clarity only by amendment in the law. Otherwise, you cannot establish. That's very difficult.
Yeah,
compared to the other loans.
It looks little difficult to address. Means if at all.
In fact, I was also reading somewhere that the income tax department takes possession or takes security of any particular asset or puts it under their custody, then that also becomes a secured to that extent. So the income tax department, before commencement of CRP, if they can take possession of it, which is actually opposite of that monetary spot and those kind of judgments.
So there are many similar actions being contemplated by various authorities right after this Rainbow judgment. It's just being 6 months of time, and a lot of innovations had taken place in the statutory authorities, right? And lot of actions we have seen in the judicial forums also, and many more will fall. I'm sure unless and until government is quick enough to implement this particular amendment and the dust is settled well before any further damage is being done. I agree, but I think all these things are just ifs and buts. There is not much clarity with regard to as to how these things will finally be settled by the authorities or by the apex court. I'll take one more matter very quickly. I think similar instance was settled in the matter of ABG Shipyard also, where the Sundaresh Bhatt, the liquidator of ABG Shipyard, and Central Board of Indirect Taxes and Customs. In this matter also, what happened was ABG Shipyard went into corporate insolvency, and some of these goods which were stored by ABG Shipyard in the custom bonded warehouse in the Gujarat port. And when the CIRP initiated on 2nd of August 2017, the IRP was appointed. So IRP sought for the custody of the goods which were warehoused at the custom port and requested them not to dispose of or auction the same. Then during 29th of March 2019 to 7th of April 2019, then different demand notices were issued to the corporate debtor to the tune of 15.80 CR by the custom authorities. On April 2019, the liquidation commenced and moratorium continued in terms of section 33(5). The appellant appointed as liquidator requested Central Board of Custom to release the warehoused good in view of the commencement of the liquidation. As usual, the port authorities did not pay any heed. Appellant had to file an application before the NCLT under section 60 clause 5 seeking direction against the Central Board of Customs for releasing the warehouse good. For the first time on 11th of July 2019, the respondent issued a notice to the corporate debtor under section 72(1) of the Customs Act for custom dues amounting to 763 crores 12 lakh 72,645. Then respondent also filed a concurrent claim for the said amount before the appellant under the insolvency. Adjudicating authority allowed the application and directed the respondent to release the goods. Respondent, of course, filed the appeal before the appellate court, challenging the order which was passed by the adjudicating authority. NCLAT allowed the appeal, thereby directing the warehouse good can be released or disposed of as per applicable provisions of Custom Act by the proper officer. Aggrieved by the judgment, the appellant, that is liquidator, filed the appeal before the Supreme Court. Now, Supreme Court framed primarily two issues: whether the provisions of IB Code would prevail over the Custom Act. If yes, to what extent? Whether the respondent authorities under the Custom Act would claim title over goods and issue notice to sell the goods in terms of the Custom Act when the liquidation process has been initiated. So these were two burning issues which Honorable Supreme Court was contemplating. Supreme Court, for the first issue regarding the scope of custom authority vis-a-vis insolvency, that Custom Act and insolvency law both operate in their own spheres. Now, section 142A of the Custom Act, which provides that custom authorities would have first charge on the assets of a SSE. I think somebody was mentioning, I think Kupchandani ji was mentioning that there are several other laws also where the similar provision is there. Income tax also has, and custom law 142A is also there. Except with respect to cases under section 529A of the Companies Act, that is where the recovery proceeding, where the preferential payment talking is all about, and recovery of debt due to the banks and the financial institution or SARFAESI, and the Insolvency and Bankruptcy Code 2016. Such an exception created under the Custom Act is an acknowledged under the 238 of the Insolvency and Bankruptcy Code, wherein an overriding power is also given to the Insolvency and Bankruptcy Code. So in net, though they agreed that both will operate in their separate sphere, but because there is a specific carve out and section 238 acts as a non-obstante clause, the provisions of insolvency law will prevail and the other will not be considered to transgress the boundaries of the other law. While considering the second issue, Supreme Court observed that issuance of notice under section 72 of the Custom Act for non-payment of the custom duty falls squarely under the ambit of initiating legal proceedings against the corporate debtors. And even under the liquidation process, the liquidator is given the responsibility to secure assets and goods of the corporate debtor under section 35(1)(b) of the insolvency. Thus, the question to whether the respondent could issue notice to sell the goods in terms of the Custom Act when the liquidation process has been initiated was answered by Supreme Court in negative. That means if you see the judgment in the matter of ABG Shipyard, which is on a, if we say, which is a date almost similar to the date of Rainbow, that judgment came on 6th of September and this judgment came on 26th of August. This judgment is a bit in difference to what the Rainbow paper talks about, and for the reasons which is I think valid. So if we can sum up, the moratorium once imposed under section 14 or 33(5), the respondent authority only has a limited jurisdiction to assess, determine the quantum of custom duty and their levies. The respondent authority does not have a power to initiate the recovery. After such assessment, respondent authority has to file the claim. In any case, the IRP, RP or liquidator can immediately secure goods from respondent authority to be dealt with the appropriate manner in terms of the provisions of the Insolvency and Bankruptcy Code. So this way, this issue of 238 can be understood. There are many, I can say there are at least another 20 odd very landmark judgments on the 238 subject with regard to different matter. I think one matter which is regarding SEBI versus insolvency, PMLA versus insolvency, which are still pending for settlement by the apex court. SEBI matter is, I think, 3 prominent matters are pending before the Supreme Court, yet not decided. Likewise, many other matters are still pending, but the sum crux, what we are able to understand is non-obstante clause of the Insolvency and Bankruptcy Code has given due importance in various pronouncements, and the clarity has come that we have to give honor to this particular proceeding. I think this is another judgment which was in the matter of embassy property, the Supreme Court judgment, old one, which was nothing but whether High Court has a power to intervene, interfere with the order of NCLT, given the availability of appellate court with regard to the provisions which are touching the wires of Constitution, that is Article 226, 227. So this is an old judgment. It was a direction to the adjudicating authority that better you not interfere with the constitutional wires subject. Those subject are the subject matter of writ jurisdiction. Only High Court and Supreme Court are competent to deal with into. So I think after that judgment, we have not seen any of such matters which are coming in a way. Now, another important matter I think we will take up. I think one we will have a break, so we will cover the 2 important.
So now High Courts will not take up any cases, or how is it, sir?
No, High Court is not barred. What is barred in this particular matter was, I think, in respect of this was a matter writ jurisdiction was invoked, and High Court of the Karnataka. The question that was the Supreme Court clarified that the distinction between the lack of jurisdiction and wrongful exercise of the available jurisdiction has to be taken into consideration by the High Court when Article 226 is sought to be invoked. So the difference was that you have to come into the writ jurisdiction to invoke the constitutional bias, right? For other civil matters, you cannot, if the matter has been filed as a civil petition, you cannot invoke the 226 or Article 136 for that matter for the purpose of constitutional bias. That was the judgment, basically. That was a distinction. Of course, adjudicating authority does not have that power, but High Court has, but you have to come through the writ jurisdiction only, then only you will be able to exercise that. Now, another matter which concerns to all of us, which is a very, I think, sweeping judgment and much debated since the time it has been, because this unsettles the understanding what we have in the admission of CIRP in respect of financial creditor and the operational creditor. I'm talking about Vidarbha judgment. But before that, let us understand what is the legal position. Section 7, Clause 5, which reads like where the adjudicating authority is satisfied that a default has occurred and the application under subsection 2 is complete and there is no disciplinary proceeding, it may by order admit such application. Further, default has not occurred or application under subsection 2 is incomplete, it may by order reject such application. Whereas in 9 Clause 5, it was mentioned the adjudicating authority shall, within 14 days of receipt of application under Clause 2, by an order, admit the application or reject the application. So in the matter of Vidarbha, the Supreme Court made a distinction between the use of shall in 9 Clause 5 and 7 Clause 5, and went up to saying that the legislature in its own wisdom has chosen the word may in the financial creditor cases to give a flexibility to the financial creditor, to give a flexibility to the adjudicating authority to travel to the other situations also while deciding the admission, whereas such discretion is not available in the case of operational creditor. Though this judgment, since the time it has been into, this has been much debated. On 12th of June, this judgment came and has become the talk of the town all across. Many criticism has also taken place. And many of the further developments had taken place thereafter. And many of the financial creditor cases have got delayed or have got dismissed also on this particular pretext also, because anybody and everybody has taken the advantage of this particular judgment, quoting, unquoting, and various applications have been filed that we are solvent and the application need not be admitted, or the request has been made to the adjudicating authority to travel into various aspects. Now, let us see what happened in this particular matter to fully apprise as to what are the facts. The adjudicating authority admitted the application which was filed by Axis Bank in application was filed against the Vidarbha Industries Power Limited for default in the debt. NCLAT refused to stay the proceeding, which were initiated by Axis Bank. CD has filed a claim by virtue of order passed by the appellate tribunal for electricity. A sum of rupees 1,730 crore is due to the electricity department, and for implementation, CD has filed the application before Maharashtra Electricity Regulatory Commission. So in nutshell, the argument of Vidarbha Industries was that on one hand, they had to recover the money from the government to the tune of 1,730 crore, and government is not paying to them. The insolvency is primarily, or inability to pay the debt to Axis Bank is primarily attributable to the dues not getting clear from the government authorities to the tune of 1,730 crore. Had those dues been paid, perhaps the dues of the Axis Bank could have been paid. That was the argument taken before the adjudicating authority also, and before the appellate authority also, and before the Supreme Court also. And Supreme Court luckily accepted the arguments and found the usage of the word may in clause 7.5 as against the usage of the word shall in 9.5. And from there, the arguments were made by their learned counsels, and basis that the order was passed that the viability and the overall financial health can also be considered by the adjudicating authority while adjudicating a petition under section 5 under section 7 of the code. Whereas in the past rulings, all these kind of judgments, howsoever solvent, howsoever good financially you may be, but this was not considered.
Sir, is not this judgment contrary to the judgment of Supreme Court in the matter of innovative industries?
100% it is. I'll if somebody asks personally to me, Mr. Jaina, I am in complete agreement, and that's the reason why I think government has already moved towards amendment, proposing the discussion paper for making necessary amendment also. In continuation, the review petition was also filed, and review petition got decided on 22nd of September 2022. Although they have stated that there is no need to intervene into the judgment, what has been delivered in August, and they have not intervened into the matter. Now, the development, what I was talking about, the development is that very recent order of January 16, 2023, which has again been passed by Honorable Supreme Court in the matter of Magan Lal Daga HUF versus Jagmohan Daga, which is Civil Appeal Diary number so-and-so. In this order, it was submitted that the Vidarbha Supreme Court judgment is contrary to settled position in law as laid down in innovative matter, what Mr. Jaina was just now talking. And the said judgment has been followed in several decisions of the Supreme Court, and even very recent judgment prior to that was in S. Krishnamurthy versus Bharat High Tech Builders Private Limited of 2022 itself. It was also submitted that the principles which are laid down in the Vidarbha will dilute the substratum of the Insolvency and Bankruptcy Code. Supreme Court has further issued the notice in the matter, and matter was listed on February 6, 2023. I think the date has been, it has not yet been decided, but the sum crux is that this matter is in review in a form in the matter of Magan Lal. This is not yet attained the finality. So we'll have to wait for the final order in the matter of Magan Lal. But yes, the debate is on. I'm saying this is one good judgment which I came across after Vidarbha judgment, wherein at least the notice has been issued. I don't know what the fate will be, but yes, there are many other adjudicating authority and appellate court orders after this which have taken base of Vidarbha judgment and passed the order in the lines of Vidarbha judgment also. Now, way forward is that amendment has been proposed wide MCA notice dated 18th of January 2023. And this section 7 is proposed to be amended to clear the doubts raised after the Vidarbha judgment. It is proposed that section 7 may be amended to clarify that while considering an application for initiation of CIRP by financial creditor, the adjudicating authority is only required to be satisfied about the occurrence of default and the fulfillment of procedural requirement for this specific purpose, nothing more. Where default is established, it is mandatory for adjudicating authority to admit the application and initiate the CIRP process. So this will, I think, bring the position originally back prior to the Vidarbha judgment. There is one more point on which the amendment is proposed, because few of the arguments had been that the timeline of 14 days has been prescribed only for determination of default and it is not for admission. So the law is going to be amended that this 14 days timeline is for admission also. It is not limited to determination of default. Now we'll take one more interesting subject, which is law of limitation. I think a lot of debate has been undergoing in respect of the applicability of law of limitation. What has been seen every time, because if you file the application, the first thing that the adjudicating authority is going to ask whether you satisfy the test of law of limitation or not. If yes, then how? If not, then why not? And all these questions are confronted by all of us. We know originally when the insolvency and bankruptcy law was enacted, the law of limitation was not specifically prescribed in the insolvency code. I don't know why. What is the intention? What was the, whether it was inadvertent, whether it was thought of, I don't know. But on 6th of June 2018, via amendment of insertion 238A, the limitation law was made applicable. And the 238A section says the provisions of Limitation Act 1963 shall, as far as may be applicable, apply to the proceedings or appeals before the adjudicating authority, the National Company Law Appellate Tribunal, Debt Recovery Tribunal, and Debt Recovery Appellate Tribunal, as the case may be. Now, once the applicability is there and there are plethora of judgment which has upheld that limitation law will apply. Limitation Act talks about certain things, and there is no specific period of limitation prescribed in the limitation law for making an application under IBC. Now, then what will happen? There is one Article 137, which says that where any other timeline has not been prescribed specifically, the period of limitation prescribed will be 3 years from the date of accrual of rights to apply. That is the law. Now, there are, if I am a student of law, then I must understand the section 14, which talks about certain exclusions of time, and section 18, which talks about the extension of limitation if there is an acknowledgement of debt. So these are some 4 principles on which the entire litigation regarding the limitation is based upon. There are multiple issues which are confronted in respect of limitations, whether acknowledgement of debt result in the extension or not, whether date of declaration of NPA would determine the limitation, whether the acknowledgement of debt in balance sheet would extend the limitation period, whether the time that you have spent in the SARFAESI proceeding will stand excluded, whether the recovery certificate which is issued by DRT gives a fresh lease of life to a claim of the financial creditor and extends the period of limitation. I think these are some broad questions on which the various judgments are based. We will see one on one and we will find out these answers. Now, there are many judgments, one of the prominent one being early time judgment, that is BK Educational Services Private Limited versus Parag Gupta and Associates, a landmark judgment issued in 2018, which says that the provisions of Limitation Act were made applicable to the proceedings of Insolvency and Bankruptcy Code by way of Section 238, and amendment has been held to be clarificatory by the Supreme Court. So the dust which was cropping up to many of the professionals as to limitation law has not been included specifically, later on done the parachute entry. So whether it will have a retrospective applicability or will have a prospective applicability. So the government said it is clarificatory in nature, so it will be having a retrospective applicability since the time it was notified, that is 1/12/2016. And all debts which are time barred, this law will not come to give them the fresh lease of life, and they will not get survived if they have already lost their life. I'll just raise one question and I'll park it, maybe we'll deliberate. In any case, these proceedings, what we achieve in the CIRP process, anyone can come and trigger the insolvency, whether it is a financial creditor, whether it is an operational creditor, whether it is a corporate debtor himself. And these are not recovery proceedings. This is also very crystal clear. And there is no bar. Limitation law is only with regard to having a legal action for recovery of your debt. It does not bar a corporate debtor in making payment to the debt which is outstanding. It is not the case that my debt has become time barred, the corporate debtor will not be able to pay off, or in acceptance of the claim while the matter has been admitted. So maybe my application for CIRP initiation may fail because of the 238A. But while the claim is invited and I file form A, B, C, my claim is admitted by the adjudicating authority or by the liquidator when the claims are invited. This is a background. Now, in this backdrop, let us continue our discussion as to what are the different aspects, what had been deliberated by the Supreme Court in this particular regard. Supreme Court in this matter also clarified that the period of limitation for filing application for CIRP process will be 3 years, which we have also discussed because of the Article 137, because there is no specific clause which talks about the limitation. Section 18 definitely provides that written acknowledgement will be considered as the start of your fresh limitation. The timeline will keep on extending. Supreme Court in the matter of Lakshmipat Surana versus Union of India in 2020 has settled the issue of applicability of Section 18 to applications under CIRP. And court has held that Section 18 of the Limitation Act applies to extend the period of limitation for so and so. Similarly, in Babulal Gurjar versus Veer Gurjar Aluminium, wherein it was dealing with a question as to whether the application under Section 7 is time barred, given that the default has occurred in 2011. While in Babulal, the Supreme Court examined the applicability of principles of Section 18 to the case-specific facts. The observation made in judgment were relied, and in subsequent decisions in the NCLT and NCLAT to hold that Section 18 would not apply to applications for initiation of insolvency proceedings under IBC. Though this judgment has been overruled later on, this was a judgment which was bit in deviation. The Babulal judgment is considered as a judgment in deviation because it's mentioned that Section 18 has no application in case of insolvency. Why I am talking? Because we must understand how the law has evolved over a period of time. The court also clarified that its decision in the Babulal did not rule out the application of Section 18 and observed that this court has not ruled out the application of Section 18 of the limitation to the proceeding if the fact situation so warrant. But it was in that particular matter that they have decided not to apply in that CIRP. Supreme Court also held that when the principal borrower or the corporate debtor, corporate guarantor admits and acknowledges the liability, a fresh limitation starts. Section 128 of the Contract Act, the liability of a guarantor and borrower is coextensive. That is also mentioned very clearly. In Supreme Court, the matter came up for debate in the Arsil versus Bishal Jaiswal, and the Lakshmipat ruling was followed that Section 18 will be applicable. Further, in Seshnath Singh and another, the Supreme Court observed that Limitation Act must be read harmoniously as far as may be applicable to the Insolvency Code. The application for condonation of delay is not mandatory to seek condonation under the provisions of the Limitation Act. So it is not that if you are having a valid justification, all that you need to justify before the adjudicating authority is a justification as to why you are coming late. And court in its wisdom, or the adjudicating authority in its wisdom, can always admit that application, and there are many matters which have been admitted also. Which also mentioned that Section 5 and 14 are not mutually exclusive, and the principles of Section 14 may be used to construe sufficient cause under Section 5. That gives a new set of life to the limitation. Supreme Court in the Dena Bank, which is now Bank of Baroda versus C. Shivakumar Reddy, 2021 judgment, it was held that application under Section 7 would not be barred by limitation on the ground that it has been filed beyond a period of 3 years from the declaration of loan account of corporate debtor as NPA. If there were an acknowledgement of debt by corporate debtor before expiry of period of limitation. There is one more important point, that the fresh lease of life should take place before expiry of your limitation. If time has already expired, then acknowledgement of debt perhaps will not revive your claim. That is the fundamental to the law of limitation. In this regard, I'll start with one very recent judgment of Supreme Court, which was decided on 19th of September 2022. Tech Sharp Engineers versus Sangvi Movers. What it decided, that for the purpose of limitation, the relevant date is the date on which the right to sue accrues, which is the date when the default occurs. So from there, your limitation period will start. Now, in this matter, the Tech Sharp Engineers Private Limited filed an appeal in the Supreme Court against the order passed by NCLAT. And NCLAT in this matter has set aside the order of dismissal of CIRP by NCLT. So the appellant and the Sangvi movers had entered into an agreement wherein the respondent has let out on hire a crane for erection of an equipment at the site of Indian Oil Corporation. The invoice was raised and sum of rupees 38 odd lakh rupees was due. These invoices were not paid. So respondent communicated via various notices to pay the invoice. However, appellant did not reply to any notice raised by the respondent. So respondent then issued the statutory notice under the Companies Act for winding up. And in this reply to the notice, which was dated November 7, 2013, the appellant has acknowledged the liability to payment of invoice. Subsequently, the respondent has filed the winding up petition in 2015 with the Madras High Court, because the provisions of insolvency were notified later on 1st of December 2016 only, which was pending due to certain defect. Insolvency law came on 1st of December 2016. The respondent issued again a demand notice under Section 8. On March 30, they filed an application under Section 9 of the IB Code. And obviously, because it was after a time of 3 years, the NCLT dismissed that application. An appeal was filed further on. Supreme Court relied on the judgment passed in the BK Educational Services and stated that Limitation Act is applicable to the applications which are filed under the Insolvency and Bankruptcy Code. And limitation will start from the date of default, or that will be considered as the date on which the right accrue. NCLT has the discretion to entertain the application after prescribed period of limitation. The condition precedent for exercising such discretion is the existence of sufficient cause for not preferring the appeal. In reference to the above, Supreme Court held that the onus shall fall on the appellant to justify sufficient cause for delay. It was argued by the counsels of the appellant that IB Code came into force only on December 6th, so 3-year time should start from here, which was completely rejected by the Supreme Court. Now, considering Section 18, Supreme Court stated that an acknowledgement of the present subsisting liability, which is made in writing, the fresh limitation will start. So last acknowledgement of liability took place in November 2013. So from 2013, November, 3-year time will start. So there was a delay in filing the application under the IB Code, and delay can be condoned by the adjudicating authority if there is a sufficient cause, and the separate application is not required to be filed. And Supreme Court mentioned that limitation for initiation of winding up proceeding in the Madras High Court stopped running on the date on which the winding up petition was filed. Now, since winding up petition was filed in 2015, that winding up petition was well within the limitation. Now, CIRP process initiated only after expiry of 3 years, whether that was in limitation period or not was a question. So accordingly, the court viewed that the initiation of proceeding before the Madras High Court, though will not save the limitation on initiation of the proceeding of the CIRP, Supreme Court allowed the appeal and set aside the impugned order passed by NCLAT, and Supreme Court held that there cannot be any straitjacket formula for accepting or rejecting the explanation furnished by the appellant application for the delay in taking the steps. When the appeal is filed against the order rejecting an application on the ground of limitation, the onus is on the appellant to make out a sufficient cause for the delay in filing the application. The date of enforcement cannot be considered for the purpose of commencement of your CIRP process. The initiation in the Madras High Court could not save the limitation for initiation of proceeding of CIRP in the NCLT under section 7. So it has to be the order essentially talked about that you have to apply it on case-to-case basis, and if at all you can justify your matter before the adjudicating authority, then the delay can be condoned and your matter can be pass the muster test of law of limitation.
So Amit, one thing. So that means every time there is an acknowledgement of debt, there will be extension of limitation, right?
But it has to come within the due period of limitation.
Within 3 years or whatever is the limitation period, it has to come.
No time, it should cross the limitation time. If once the limitation time is already over, let's say the debt was due in 2011, 3-year time got over in 2014, and now we are sitting in 2018. Now, even if the acknowledgement of debt is made, whether it will revive the application, answer is no. However, still
correct. So it has to be within the period of yes.
Yeah, I think Mr. Jaina has raised the hand. Yeah, Mr. Jaina.
And secondly, Amit, one more thing is that whether you can cover that whether the acknowledgement in terms of the provision in the balance sheet would also be treated.
I have a case. I'll discuss that.
Sir,
Yeah.
I have a question, sir.
Yeah.
Sir, may I ask?
Yeah,
My first point is limitation period. Does limitation period stop running when the CIRP is commenced? Because suppose in 2019 limitation period starts, and 2022 or 2023 I take action against the personal guarantor. Then my point is that from 2019 to 2022 limitation period stops running because it is a legal process. When the legal process is going on, this limitation period stops. So if that debt is not time barred on 2019, how can you say it is time barred in 2023? Because these 4 years, this process is going on. This process is a whether CRP or liquidation. This is a legal process.
Only one point. It will stop, but stop against whom?
It will stop against the corporate debtor. If it is stopped against the corporate debtor, then why it is not stopped against the personal guarantors? Because when both the debt, when the liabilities are coextensive, both the parties. Therefore, when it starts against the corporate debtor, it should the limitation period should stop running against the guarantors also. That is my point, sir.
No, that point is having some logic. I'm not saying that is not having some logic, but point is that when these are two separate actions which you have got in terms of the provisions of law. Now you can initiate, that is what the law is, that guarantees are coextensive. You can initiate the invocation of guarantee proceeding even without initiating the recovery proceeding against the principal.
Sir, exactly. That is my point. Because
Now,
till that date, I have not invoked. Had I invoked that personal guarantee, then it would have been separate. But till now, I have not invoked personal guarantee. So when I have not invoked personal guarantee, till that date, the personal guarantee, the liability of personal guarantor and the corporate debtor are coextensive. They will run parallelly.
No, now point is that the example that you were quoting, unquoting, that your account became NPA on one particular date, right? CIRP proceeding, whether will come at a similar footing to the other recovery proceeding and will continue to give you a fresh lease of life, or will disregard this particular period for the purpose of running the limitation. I have my own doubts, because
CIRP started within the limitation period 2015, and after that, when it became NPA, within 3 years, CIRP started. But till that date, I have not invoked personal financial creditor has not invoked personal guarantee. So then the period started. So my point is that when CIRP started, till the liquidation completes, that period should be excluded. During that period, limitation should stop running. That is my limited point, sir.
My point is that
because I have not invoked personal guarantee.
As a student of law, I am not able to reconcile on this point, that why during the CIRP period, why the CIRP period should be excluded for the purpose of counting the limitation time for the invocation of guarantee. I am having my own doubts, because this is not a proceeding for recovery. You have gone.
Sir, I am coming to that point. You are also telling individual insolvency process. That is also not a process of recovery. Then in that case, individual insolvency process should be treated as a recovery process. Sir, I am coming to that point. Then individual insolvency should be treated as a recovery process. Then why individual insolvency they are treating as a resolution process? If it is a resolution process, then this process, this period should be treated for excluding the time period. If it is a recovery process, then if I have gone against the personal guarantor in the DRT, then my period of limitation period should stop running from the date when I filed the case against them in DRT. Because they are telling, because what NCLT is telling, if you have gone to DRT, that will not be treated, because individual insolvency resolution, insolvency process is not a recovery process. Then my point is that, sir, sir, it is understood. It is reasonable. It is reasonable to understand CIRP is a resolution process. But how can we tell individual resolution process is a individual insolvency process is a resolution process?
It is
Definitely that is a recovery process. Because CIRP is for resolution of the corporate debtor. But individual insolvency is not a resolution process. It is simply a recovery process. So when the case is filed against them in the DRT, from that day, it should be treated. The period should be treated as stopped running.
No, Mr. Jena. When we see the individual resolution process, so in case of individual insolvency, there are three processes. Let us understand now, because you have asked. Let us discuss that also. There are three processes which are available. One is the insolvency resolution process, which is a process which is covered under section 95 and onward, right? There is a process of bankruptcy, right, which is a process which is a separate to insolvency, right? Any individual insolvency resolution process, if not successful, does not automatically result into bankruptcy. Please understand, CIRP process and individual insolvency resolution process are replica. It is in respect of corporate, and individual insolvency is in respect of individual. Whereas end result of CIRP is compulsory liquidation or resolution. If not resolution, then liquidation. There is no option available in case of CIRP that you don't go for liquidation without resolution. Either there will be a resolution, then you are escaping liquidation, or if there is no resolution, then compulsory liquidation is the result. Whereas in case of individual insolvency, even if the individual insolvency fails or there is no repayment plan, it does not terminate as a bankruptcy. Please understand. It only gives a right to a financial creditor or to a corporate, to a debtor to move an application for bankruptcy. Do you agree?
Yes, sir. I agree on that.
If that is the case, then individual insolvency is oriented towards rehabilitation of an individual. It is a social initiative that anybody who has started his business and he's failed, he should get a fresh opportunity to start his life again. So repayment plan, let me give you the example. Same example that we were discussing in the morning. ABC Limited has taken a loan from State Bank of India, 100 crore, right? Now, resolution plan was approved. 50 crore has been paid. 50 crore is still outstanding. Mr. A, who has got certain wealth, State Bank of India is of firm belief that if I initiate the individual insolvency, or Mr. A himself, let us not take the case of State Bank of India, Mr. A himself initiates the individual insolvency. He says that sooner or later some guarantee may come to me, guarantee may be invoked, and I may end up paying something. And I may keep on running from pillar to post to restart my own life. Why to do so? Why not I go to adjudicating authority, subject myself to individual insolvency, make a repayment plan, and my repayment plan is only for rupees 1 crore. I am saying against the liability of 50 odd crore which I have to pay, I am saying I am having one Bangalore which I will sell, and I'll pay off your 1 crore in settlement for entire 50 crore of liability. Bank agrees and the repayment plan is approved. Chapter ends over there. So it is not oriented towards recovery. That is my point. Now, even if this process has terminated, let us say the State Bank of India says that I will not accept your 1 crore repayment plan. I reject that plan. What will happen? Will Mr. A considered as a bankrupt? Answer is no. To be declared as a bankrupt, State Bank of India has to file a fresh application for commencement of bankruptcy. And once the bankruptcy application is admitted, then Mr. A will be declared as a bankrupt, bankruptcy trustee will be appointed, his assets will be liquidated, and
sir, I agree. Sir, I agree. Sir, then if you tell it does not stop running, limitation period does not stop running. Okay, I agree. Then my point is that the acknowledgement of debt by the resolution professional or the liquidator again revives the limitation period. Then the limitation period starts running from that debt. From the debt, liquidator acknowledges the debt through form D against the financial creditor.
I take your point. I think I'll connect you separately, because this may become more a personal discussion. The other people may think that we are doing a personal chat. So we will connect. I got your point, and I'm not completely disagreeing, but I am having my own difficulty.
Sir, this is the forum. This is if you think it's a personal, this is the forum.
No.
And sir, This is because if we discuss just simply section 238A, this is if we discuss that, then there is for last 5 years we have been practicing IP, and if we don't discuss these things, where will you discuss these things, sir?
I completely agree, Mr. Jaina. What I'm saying ki we have many things to discuss. We will park this issue. I will personally discuss separately with you on this front because I'm having no more answers to that. What I have understood from you is okay. If somebody else has got some view, I think I'll be.
Thank you.
My point is that we have debated enough. Now let us move forward. I think we will be able to take many more cases with this regard. I think what Mr. Khubchandani was also indicating. I'll just take one.
Sir, I have one small doubt, sir, not pertaining to this one.
Yeah,
We said that if the amount is reflected in the debtor's balance sheet, it is as good as the acknowledgement of debt.
Correct.
Right. Now, how do we prove it? Because the debtor's balance sheet, if you see, it will have sundry creditors, 100 crores. Now, in that 100 crores, whether my name is there or not, how do we ensure? So that's what we are facing in some of the operational creditors filings.
That's a point that you have raised, which is valid. So, in many of the situations, the balances are open by way of a schedule or by way of a notes.
No, so schedule will have only considered good, considered not bad, due to MSMEs.
It depends.
Round figures. So suppose 100 crores total will have 40, 40, 40, 20, something like that.
So unless you are having a figure,
trial balance.
Yeah, but unless you on the face of the balance sheet or unless the director himself agrees, yes, the breakup of this 10 crore includes your 1 crore also, that's a different story. Otherwise, you have no other way now that you will be able to prove. Books of accounts, if he is able to provide you, that's a different story. Now,
why will he provide? He will not provide us.
No? Why he'll provide? That I agree. It's a very difficult proposition. So that's a challenge. But as far as the settled legal position is concerned, the legal position is very well settled that the acknowledgement in the balance sheet, I think this is the case. State Bank of India versus Krishidhan Seats. This is again a Supreme Court judgment, and this was decided last year in April, which says that an acknowledgement in a balance sheet without a qualification can furnish a legitimate basis for the determination as to whether the period of limitation will stand extended so long the acknowledgement was within the period of 3 years from the original date of default. Now we can see this case for further understanding what were the facts. In this case, the application was filed by State Bank of India against the corporate debtor, which was Krishidhan Seeds Private Limited. The application was rejected by the NCLT. The respondent, that is Krishidhan Seeds, has received the credit facility from State Bank of India, and total outstanding was 102 odd crores. And default occurred, and the account became NPA on 10th of June 2014. Then SARFACI action was initiated, and they continued to be engaged on the negotiations and all. Then letter was issued by the respondent to the appellant dated January 19, 2016, offering one-time settlement of rupees 61 crore in lieu of all its debt liability. Respondent by letter dated September 18 unilaterally revised the one-time settlement letter to 40.6 odd crore, which was refused. Later on, application for initiation of CIRP was filed on the ground that there was a default on the part of the respondent in paying the total debt amount of 189 odd crore. Application was rejected. The NPA was declared on June 10, 2014. Proceedings were initiated on September 19, 2018. That is beyond the period of 3 years from which they got the right to apply. Now, referring the judgment of NCLAT in V. Padma Kumar versus SASF, that statement contained in balance sheet cannot be treated as acknowledgement of liability under Section 18. This was a position until 2018, I believe, till this NCLAT judgment was there, until this position was clarified further. Now, Supreme Court observed that acknowledgement in a balance sheet without a qualification can be relied upon for the purpose of proceeding under the insolvency. Supreme Court held that acknowledgement in a balance sheet without a qualification can be relied upon for the purpose of proceeding under the insolvency. Neither NCLT nor NCLAT had a benefit of adjudicating upon the factual controversy in the context of the decisions of the court. The principle which emerged that the provisions of Section 18 of the Limitation Act are not alien to and are applicable to the proceedings of the insolvency and bankruptcy, and acknowledgement in a balance sheet without a qualification can furnish a legitimate basis for determining as to whether the period of limitation would stand extended, so long as the acknowledgement was within the period of 3 years from the original date of default. So with this, the position with regard to the acknowledgement of debt in the balance sheet gets clarified. Now, answering to the question what Mr. Ravi is asking, that in your balance sheet, generally the breakup of grouping is not provided. So in those cases, we are helpless. We will not be able to prove it unless and until we get a breakup from the corporate debtor, which I agree is very difficult, which will not be possible in many of the cases. I'm not saying in all the cases, but yes, unless and until you have some other further communication prior to invoking all this process, yes, it can be definitely.
No, but Amit, when a balance sheet is prepared, you can easily establish the amount. There is no problem because, how do you arrive at that 50 crores or 100 crores? You have the complete schedule for that,
No. What happens when you, let us say you have a case of a sundry creditor, right? Now in sundry creditor, I have shown a liability of 100 odd crores. Now, who are the, what I will say, the creditor having period more than 6 months, creditor having period more than 1 year, creditor having outstanding for more than 3 years, MSME, non-MSME. But I'll not give the breakup of party name, which is not mandatory as per Schedule 3. If I have, many of the companies are giving, many of the companies are not giving, but law does not mandate that I have to open the name of the party as to whose dues are outstanding, right? So if the corporate debtor has prepared a balance sheet where the name of the party is not appearing, then how you will establish that this 100 crore include your 10 crore also? That is a question what Mr. Ravi is asking. There is no way that you will be able to retrieve that information. I agree that many of the companies are giving this detail, but not necessary that all companies' balance sheet will be having similar kind of detail.
No, but see, whenever you need to put in evidence, you can always, get this information from the company. They will have to provide you that, this is the basis of calculation of 100 crores.
I agree. It will trigger once this argument is made before the adjudicating authority, you can make a request to the adjudicating authority to ask the corporate debtor to submit a breakup of that 100 odd crore. So if they provide the breakup along with the auditor certificate and the statement, I think if you are sure that that is a amount which was including your amount, your detail also, maybe in 2021, the amount was including your name also. Now in 2022, if the amount is not included, limitation will be over. So they have deliberately excluded your name, but the amount is still continuing. So you can definitely put your matter before the adjudicating authority, and adjudicating authority will be asking the question to the corporate debtor for submitting necessary certificate from the auditor based on books of accounts, or submit the copy of the books of accounts. I think that's the only way by which you will be able to prove that. Another, I think we'll take one more aspect regarding the limitation, very interesting one, recovery certificate. That what will happen in any case, we know that this law got into force on 1st of December 2016, and prior to that, many of the SARFAESI action, RDDB action were already initiated, and those have now culminated into the issuance of the recovery certificate. Whether the recovery certificate will give you the fresh lease of limitation period or not, that was the question. In this matter, Kotak Mahindra Bank versus A. Balakrishna, this was a judgment which came on 30th of May. Kotak Mahindra Bank, who was an appellant, he was an assignee of certain loans in respect of which Prasad Properties and Investment Private Limited stood as a guarantor. So Prasad Properties and Investment was a guarantor, and KMBL has acquired that loan in the, you can say, assignment process. Now, settlement process was initiated on 13th of October 2006. The DRT issued a recovery certificate on 7th of June 2017. And further on 20th of October 2017 in favor of the appellant, that is Kotak Mahindra Bank. Now, in basis the recovery certificate, appellant filed the application under Insolvency and Bankruptcy Code. Although this issue has also been confronted all across, and I can recall at least 3 or 4 major judgments at NCLT Kolkata, NCLT Delhi, and appellate court also, where the issue has been decided in a contrary manner. And one view was that even in, I think, AT has given the view that recovery proceeding cannot give a rise to your fresh commencement of limitation period, and recovery certificate cannot be considered as a debt for the purpose of Insolvency and Bankruptcy Code. Settling all these issues, in this matter, what Kotak submitted that the application under section 7 was filed by the appellant well within the period of 3 years from the date on which the recovery certificate were issued. Now, there was a judgment of Dena Bank, which we discussed earlier, that the fresh period of limitation will start from the date of issuance of the recovery certificate. Respondent, that is the property entity, that is Prasad Properties Investment, they submitted that the cause of action in respect of debt has merged into DRT order issuing a recovery certificate. Therefore, second proceeding on the same cause of action will be prohibited by the doctrine of res judicata. Very interesting. And this has been settled by the appellate court also in one of the matters. And they have also opined that res judicata will apply, and now you cannot initiate the fresh proceeding against the same cause. In view of section 1922A of RDB Act, which states that a recovery certificate shall be deemed decree for the purpose of initiation, inter alia winding a proceeding under the Companies Act, IBC proceeding cannot be filed pursuant to a recovery certificate. Now, the judgment of Dena Bank is rendered without considering the correct position of law, as it does not correctly consider the provisions of section 19 clause 22 and 19 clause 22A of RDB Act, as well as there are certain provision 5, 7, 5, 8, 6, 14 of the Insolvency and Bankruptcy Code. They also stated that Dena Bank judgment is contrary to the judgment of Supreme Court in the matter of Jignesh Shah of 2019, wherein the initiation of CIRP was held to be barred by limitation despite pending recovery proceeding. And in the matter of Gaurav Har Govind Bhai Dave and Arsil, wherein application for, so there was many controversy in this particular, and many argument and counter arguments were made. Supreme Court observed that recovery certificate is a financial debt within the meaning of 5 clause 8 of the Insolvency and Bankruptcy Code. We referred some time back 5.8 also. The application under section 7 of IB code may be filed in respect of default as defined under section 3 clause 12 of IBC to mean non-payment of debt. Section 3 clause 11 of IB code defines debt as a liability in respect of claim, and section 3 clause 6 of IB defines the term claim to mean right to payment. Beautiful corroboration of the different terminology, debt, claim, liability was used in the judgment, and finally the Supreme Court stated that it is a financial debt in terms of the provisions of section 5.8, and this judgment is having a backup of judgment of Dena Bank, and basis that they have summarized this particular position. So this position is also. So on limitation, there are though many aspects, because I think on limitation alone, there will be more than 100 celebrated judgment, maybe not of all Supreme Court, but NCLT and especially NCLAT and Supreme Court judgment if we put together. So all major issues with regard to the limitations have been discussed and decided by the Supreme Court. And there is one more very just a general issue, that during COVID period, when the COVID embarked, the Supreme Court suo motu took a cognizance that the period from 15th of March 2020 till 28th of February 2022 shall stand excluded for the purpose of limitation as prescribed under the general and special law. So this is a general order without filing any application. Supreme Court has taken cognizance on their own, and from time to time they have passed and revised these orders. So basis that these will be applicable for the insolvency proceedings also, and the limitation provision shall also keep on extending basis this particular provision, basis the order of the Supreme Court. I think we can, Nitin, should we break or what do you suggest? Nitin, are you there? I think he's not there. So I'll take a view of the members. Should we break, and break for what time? And then we can.
So at least 45 minutes.
All right. So this is one. So 2:15 maybe.
Now say 140.
140. So 40 minutes, 45 minutes. So 2:15 or 2:20 should be okay.
Right, sir. 2:20.
So can somebody just drop a message? Maybe somebody may be away. So we can just reassemble at 2:40 after the next break, and then we will discuss some more interesting aspect, especially the provident fund and the gratuity issue. I think we'll start from there, and we'll see how many more judgments we can cover.
Break is till what time, Amit?
2:40 we will resume.
2:40.
2:40. Yes.
Okay, thank you.
You said 2:20. You said 2:20.
2:20. Sorry. I stand corrected. 2:20. Just put a message also in the chat box.
No, we all put it. We have read it 2-3 messages. We put it 2:20.
2:20. Correct.
And same login works again, no?
Yeah.
You log out now.
Yeah. Yes. Good afternoon, friends. Can we resume?
Yes, sir. Yes, sir.
All right. So limitation, we have so far discussed 8 major subjects on which rulings of Supreme Court we have analyzed and we have understood what is the present legal position in respect of these matters. We'll see a couple of more matters before we actually consider the discussion on Provident Fund and gratuity, which is going to take quite some time. So we'll park that for the last discussion, and prior to that, we will cover couple of more relevant subject. One of the issue which keep on coming now and then is with regard to the withdrawal. As we know, earlier there was no provision for withdrawal, and Supreme Court through their orders have been allowing the withdrawal of the CIRP application. Now, because 12A is there, 12A says that adjudicating authority may allow the withdrawal of application on application which will be approved by 90% of vote share of the committee of creditor, if committee is constituted. If committee is not constituted, of course, this voting is not required, and the application can be filed straight. In this regard, only the matter came up for discussion before Supreme Court in the matter of Ashok G. Rajani versus Bacon Trusteeship Limited. In this matter, the appeal was made against the order of principal bench NCLT, and then further appeal was made to Supreme Court. NCLAT has passed the interim order against which this appeal before the Supreme Court was passed. So NCLAT, what NCLAT did, NCLAT issued a notice of appeal, but did not restrain the IRP from proceedings under CIRP. However, IRP was restrained from constituting the committee of creditor till the date of hearing. This has been very common practice all across the jurisdictions, and we have been encountering similar kind of order where NCLT has admitted the application, later on settlement takes place, and the withdrawal application is filed, and the appeal is made before the NCLT, and NCLT issues the notice, but does not go a step forward to stop the CIRP process. So this matter is bang on that particular subject, where the similar situation arisen, and parties had amicably settled their dispute and had entered into the formal settlement agreement also. Considering the settlement between the parties, an interim stay of publication was granted under section 13, and later on 21st of August 2021, 12A application for withdrawal was filed. On 18th of August, NCLAT stayed the formation of Committee of Creditor, but handed over all the assets and proceeds with the CIRP to IRP, even though matter was settled between the parties. Now, Supreme Court, while hearing the appeal, the question of approval of Committee of Creditor by requisite percentage of votes can only arise after Committee of Creditor is constituted, which is a very logical analogy. The withdrawal of application of CIRP by the applicant will not prevent the other financial creditor from taking recourse to proceeding under the insolvency. The urgency to abide by the timelines for completion of the resolution process is not a reason to stifle the settlement. And Supreme Court, while dismissing the appeal, directed NCLT to take up settlement application and observed that the reading of the statement of object and reasons with statutory rule 11 of the NCLT rule enables the NCLT to pass order for ends of justice, including order permitting an application for CIRP to withdraw its application and to enable a corporate body to carry on the business with the ease, free, and the impediment. Further, it goes on to say that settlement cannot be stifled before constitution of Committee of Creditor in anticipation of claims against the corporate debtor from third person. The withdrawal of application for CIRP by the applicant would not prevent any other financial creditor from taking recourse to the proceeding under the insolvency and bankruptcy code. So that was a finding that was made. Another important issue which keeps on deliberating in the different forums is whether insolvency is a recovery mechanism or not. Hundreds of judgments have been passed on this particular subject alone, whether this is a recovery proceeding or not. First issue that came for consideration was in the matter of celebrated judgment of Mobilox Innovation versus Kirusa Software, and wherein it was very categorically stated by Apex Code that IBC is not intended to be a substitute of a recovery forum. Though me and you can agree that last six and a half years of time has proven otherwise, that this is more, but nonetheless, the larger objective, if being is served, then nobody minds whether we call it a recovery forum or otherwise. Very recent judgment of Arcel versus Tulip Star Hotel. The Supreme Court interpreted the provisions of insolvency, and those findings are very important for us to understand as to what the Supreme Court has stated with regard to these proceedings. It says that insolvency proceedings are designed to ensure that the business or commercial activities of the corporate debtor are continued by the resolution professional upon imposing a moratorium to give CD some reprieve from the coercive litigation, which will drain the corporate debtor of its financial resources. The code is not just a statute for recovery of debt. It is also not a statute which only prescribe the modalities of liquidation, unable to pay its debt. It is essentially a statute which works towards the revival of the corporate body unable to pay its debt. Yes, recovery happens, which is incidental. The preamble to the Insolvency and Bankruptcy Code is talking about value maximization. And in that value maximization and resolution process, yes, the stakeholder do recover certain part of their money. So maybe that is incidental, but that's not the only objective of insolvency. Another objective is equitable treatment of all the creditors of the corporate debtor to protect the livelihood of workers by revival of corporate debtors. So it is the larger objective which is being mentioned in the preamble also. So application which is being filed under section 7 is definitely in distinction to the recovery suit that is being filed under the DRT law or under the civil procedure code. Similarly, another important matter was in the matter of invent asset securitization and reconstruction private versus Girnar Fiber. This order also came on 25th of April 2022, wherein the observations of the court were that this code is essentially intended to bring the corporate debtor to its feet and are not for money recovery proceeding. In this matter, Supreme Court again upheld the decision of NCLAT, holding that time and again they have been expressing that this is not a recovery code, and it has been expressed and explained by this code are essentially intended to bring the corporate debtor to recover. One more matter, I think, which is very interesting and very right observations had been made was SS Engineers versus Hindustan Petroleum Corporation, which was decided on 15th of July 2022. And it was stated that it is not the object of insolvency that CIRP should be initiated to penalize a solvent companies for non-payment of disputed dues claimed by the operational creditor. This judgment has been quoted, unquoted by many of the corporate debtors to defend their matters. In this matter, HPCL Biofuels was a wholly owned subsidiary of Hindustan Petroleum Corporation. They floated a tender to enhance the capacity of their boiling house. SS Engineer, who was operational creditor, submitted their offer. Subsequently, the purchase order were issued. Later on, it was found that there were certain shortcomings in the contract. So HBL wrote various letters and emails to the SS Engineers that they had acted in violation to the general terms by raising improper invoice for the materials which had not been supplied, not renewing the bank guarantees, failing to effect supplies and complete work within the stipulated time. It was alleged that the service rendered and the material supplied by the appellant were of the poor quality, and as a result of which HBL had to suffer losses. HBL also contended that there was no payment outstanding from HBL to the appellant in view of the same. The appellant issued 2 demand notice under section 8 of IB code, respectively to HBL. Although HBL replied to demand notice disputing the claim, thereafter the appellant filed an application for initiation of CIRP under section 9. The application was admitted, rejecting the contentions of HBL that there were pre-existing disputes between the parties in respect of claim of the appellant. Now, appeal was filed before NCLAT, and NCLAT allowed that appeal. An order passed by NCLAT was NCLT was set aside. Now, subsequently, the appellant filed an appeal in Supreme Court challenging the order passed by NCLT. The question to be adjudicated upon was whether the application under section 9 by OC should have been admitted by NCLT or not. Now, Supreme Court, quoting unquoting the celebrated judgment of Mobilox and Kirusa with regard to dispute, the court observed that while examining the application under section 9, the adjudicating authority will have to examine whether the operational debt exceeds the prescribed amount, whether the evidence furnished with the application showed that the debt was due and payable and had not been paid, whether there was existence of any dispute between the parties or not. If answer is positive, based on that, the application will be admitted or rejected. In this case, the correspondence that took place between the parties showed that HBL was disputing the claim of the appellant on the contention that appellant was backing out from its commitment and not adhering to the time frame as per contract, thereby causing losses to HBL. Due to this, HBL was constrained to procure material from the other vendors and had to incur the losses. Therefore, HBL declined to release the money on the ground of poor quality work and breaches. Going by the test of existing of dispute as was framed in the matter of Kirusa, the apex court found that there was a pre-existing dispute with regard to the alleged claim of the appellant against the HPCL or its subsidiary. It is not for the adjudicating authority to make detailed examination of the respective contention and adjudicate the merits of the dispute at this stage, as was also held in the matter of Kirusa. Accordingly, Supreme Court held that the NCLT exercising the power under section 7(9) is not a debt collection forum. The IBC tackles, because these are all summary proceedings, these are not to be carried out in a detailed manner as are there in the case of the debt recovery forum. So the sanctity of these forums should be maintained by way of not entering into the areas which are not supposed to be while doing a limited summary trial. There are a couple of more interesting judgments. One matter was that in the matter of Duncan Industry versus AJ Agrochem, wherein the issue was there was a applicability of a T Act, and which was providing, the T Act provided, section 16 provided that if a T undertaking is proposed to be taken over by the any of the person, then it will require the permission of the central government. Now, question came whether consent of central government will be required for initiating the CIRP process also. So the court mentioned that CIRP process cannot be limited to the appointment of receiver or winding up. The object is revival. So CIRP process can be initiated even without the approval of central government. Then there are some small matters like whether the service of notice on the other side is mandatory, though the law is very clear in the matter of Jai Balaji Industries versus State Bank of India. The appellant in the present appeal is the corporate debtor and is aggrieved by the NCLAT order with respect to the admission of application under Section 7. The appellant pleaded that the Honorable Supreme Court that it has denied the right to be heard, which is the principle of a natural justice. Rule 48 of the NCLAT rules clearly stated that the service of notice on the other side, pursuant to the issuance of notice by NCLAT in the appeal, regardless of supply of the advanced copy of the appeal paper book before the issuance of notice by the NCLAT. Further, Section 52, Rule 52 of the NCLAT rule categorically state that the judicial section of the registry of NCLAT shall record in the notes of the registry column in the order sheet the details regarding completion of service of notice on the respondent. Thus, the appellant appeal was allowed as no processing fee for the issuance and service of notice was paid by the respondent, and the matter was remanded back to NCLAT to be decided on the merits. Another question was whether the provisions of Insolvency Code overrides the provision of the Mumbai Municipal Corporation Act, and hence the resolution plan approved by NCLT acquires primacy over all legal provisions. I think though we don't require to read the entire judgment, the order was, yes, the resolution plan once approved will be binding even on the government corporation also. There is no second thought on this particular subject. I'll not travel into the subject matter of Mobilox innovations versus Kirusa software judgment. I think by and large the entire fraternity is aware, because that is the still a landmark judgment with regard to the case of admission of operational creator, and especially with regard to the dispute. So though it is used by both of the party, even corporate debtor is also using this judgment, and the operational creator also uses the same judgment. Depending on their own fitability in the particular case, the arguments are taken, and this judgment helped the adjudicating authority in deciding these matters. Another matter, I think, from where the sea change started in respect of the home buyer cases was a Pioneer Urban Land and Infrastructure Limited versus Union of India, a judgment of 2019, where essentially the issue was whether the amount that was raised by allotee under the real estate project shall be deemed to have a commercial effect of borrowing to classify them as a financial creditor. Now, in this matter, the constitutional validity of 58F, which was amended by the Second Amendment of 2018, was challenged. And as per the amendment, if you recall, the amount raised by the allotee under the real estate project was deemed to be an amount having commercial effect of borrowing. And ultimately, such allottees were considered as a financial creditor under the Insolvency and Bankruptcy Code. Though there are different category of home buyers, we have to apply in what category, which kind of people will fit into the criteria of financial creditor, which will not fall. In this particular matter, the real estate companies contended that the amendment is violative of Article 14 of the Constitution, as it treated unequals equally and equals unequally. Having no intelligible differentia, it was also contended that the amendment was against the very objectives of the code. The amendment was violative to 19(1)(g), as real estate developer with sound management and perfectly solvent could fall under the rigors of CIRP. Supreme Court referred the report of Insolvency Committee, which deliberated that if forward sale or purchase transactions are structured as a tool or means of raising finance, there is no doubt that the amount raised from the allottees will also fall within the section 5(8)(f) of the Insolvency Code. So Supreme Court highlighted the difference between the real estate developers and the operational creditor on the certain grounds. And one of the grounds that in operational debt, the person supplying the goods or service is a creditor, which is exactly opposite in the real estate project. An operational creditor has no interest in or stake in the corporate debtor, while the allottee has. In operational debt, there is no consideration for time value of money, but in real estate project, money is raised from the allottee against the time value of money. So all these three elements were found positive, and Supreme Court held that the amendment rationally equates home buyers to the financial creditor, just like the individual debenture holder or the fixed deposit holder, and does not amount to infractions of Article 14 of the Constitution. So the constitutional validity was upheld. Another incidental issue was whether the creditors of a holding company will be treated as a financial creditor of subsidiary on the ground of security provided for the facilities granted to the holding company. This was a matter of Anuj Jain IRP versus the Axis Bank. And in this matter, the issue was settled that the financial creditor of holding company will only be considered as a secured creditor of corporate debtor, as there is no direct nexus between the financial assistance given to the corporate debtor on the time value of money. For arbitration also, there is one judgment available, which is K. Kishan versus Vijay Nirman Company, wherein the issue was raised whether the CIRP proceeding can be initiated where the arbitration award has been passed. So it was clarified that insolvency and bankruptcy proceedings cannot be invoked for implementation of the award of arbitration. Now in moratorium also there are a couple of very good judgments.
Sir, one small doubt.
Yeah.
For arbitration award, you can't this one, but for a DRT order, you can initiate.
Yeah. So
how is it different between that and this?
Now, I don't know, because I think this order might be, I am told that there is one more recent matter of arbitration which has been in appeal before Supreme Court. Because that judgment, what I was quoting in the previous session, was with regard to the order from the DRT with regard to the recovery proceeding. Now, where the order has been passed and recovery order will be considered as a financial debt and you can initiate the proceeding. Now, whether the arbitration award, logically to me, it should fall in the same footing as it qualifies in the definition of a financial debt. But this order is quite old. This order came on 14th of August 2018 and the other order was of 2021. So maybe I think in the new order, which new matter which is in appeal, maybe the Supreme Court has to revisit the previous settled position, what they have done in the matter of Vijay Nirma. But as of now, I have not found any other order of the Supreme Court so far which has considered, and I believe in NCLT and NCLAT there are conflicting orders that in many of the cases, no, I have not came across any case where the arbitration award has been considered as a financial debt for that matter. But yes, negative orders are there. Many orders are there, in fact. So we have to wait, I think, unless the position is revisited. Now on moratorium, as we know, as soon as the insolvency process is initiated, Section 14 moratorium comes into picture, and Section 14 is very important to understand as to what is the length and breadth of this particular provision. Because it says that subject to provisions of subsection 2 and 3, on insolvency commencement date, the adjudicating authority shall by order declare moratorium for prohibiting all of the following actions, namely, what are those actions? Institution of suits or continuation of pending suits or proceedings against the corporate debtor. Now, mark the word, I think suit we all understand. So institution of suit is restricted, continuation of pending suits is restricted, institution of proceedings against the corporate debtor is restricted, continuation of proceeding against the corporate debtor is restricted. Of course, you cannot go for execution proceedings also, execution of any judgment, decree, order of any court, tribunal, arbitration panel, so and so. Then second restriction is on transfer, encumbrance, alienation, disposal of the assets of the corporate debtor, or legal right or the beneficial right, or any action to foreclose, recover, enforce the security interest created by the corporate debtor in respect of the property, or any action under SARFAESI, or recovery of any property by the owner or lessor where such property is occupied by or in possession of the corporate debtor. Now, some 4 or 5 interesting analogies in respect of Section 14. One is, what is the meaning of proceeding? This issue has came up for deliberation in more than hundreds of matters, invariably all the matters, whether the income tax department can continue the assessment proceedings during the pendency of CIRP. What is the legal position in this particular regard? Now, if I go to the term proceeding and read the definition of proceeding under the Black's law, because the term proceeding is not defined in the insolvency law. Literal meaning of proceeding can be understood from the judgment that was in the matter of Power Grid Corporation versus Jyoti Structure. And they mentioned that because section 14(1)(a) is not preceded by word all, indicating that moratorium proceeding will not apply to all proceeding against CD. That means section 14 would apply to proceeding which are for the benefit of CD, not the other proceedings. What does that mean? So income tax department or GST department or customs department or any other department can continue the assessment proceeding. However, enforcement proceedings cannot continue. Once the moratorium starts, once the company is admitted to CIRP, at max what the income tax department can do and rather should do is to complete the assessment proceeding, so that tomorrow if the company goes into liquidation, if resolution does not happen, then the claim can be filed before the liquidator for the purpose of necessary distribution, whenever distribution stage comes, or for the purpose of collating at the time of CIRP. So enforcement cannot be done, but assessment proceeding is not barred. Now, another interesting question extended, whether the proceedings can include criminal proceeding also. Supreme Court considered this issue with regard to criminal proceeding, with regard to maybe dishonor of check, which are section 138 proceedings, are proceedings which are criminal in nature. And Supreme Court mentioned that the intent of legislature is to allow maximization of value of all the stakeholders. Supreme Court held that the interpretation pertaining to the aegisdem generis were incorrectly applied to the earlier High Court decision to hold that the word proceeding does not include criminal proceeding. Supreme Court held that the word proceedings cannot be limited only to civil proceeding, and that any matter that can create a debt or encumbrance on the assets of CD, including criminal proceeding, were to be prohibited by the order of moratorium. The Delhi High Court, however, has taken a different view on the effect of moratorium on the proceeding under the corporate debtor under the Prevention of Money Laundering Act. In the enforcement of Directorate Enforcement and Axis Bank, the High Court of Delhi has held that since the objective of PMLA is distinct from the purpose of IBC, the later legislation does not prevail over the formal. Thus, the criminal proceeding which seeks to enforce civil remedy and are in nature of the quasi-criminal proceeding will be hit by the section 14 of Insolvency and Bankruptcy Code. Though there are a couple of more judgments also, I still remember there is one more judgment of Supreme Court which clearly says that the criminal proceedings are not the proceedings intended under section 14, and these proceedings can continue as far as they are not creating any charge on the assets of a company. These are proceedings which are personal to the directors or personal to the person. They are not against the corporate. So to that extent, they will not hit by the provisions of section 14 of insolvency with regard to the moratorium. Of course, the writ jurisdiction is out from the clutches of the moratorium. Now, there is one more aspect with regard to the moratorium to the management of the corporate debtor. Now, once the CIRP is initiated against the corporate debtor, it does not provide immunity to the directors, promoters, management from any legal proceeding. In many of the matters, the personal guarantors and these people have claimed a moratorium, but Supreme Court has held that it is only intended for the purpose of protection of the assets of the CD, and this protection is not available to these other people. So is the case with the personal guarantors also. Supreme Court considered this issue of applicability of moratorium on the personal guarantor in State Bank of India versus Ramakrishnan, holding that since section 14 does not make any reference to the personal guarantor, the moratorium will not apply to the personal guarantor. One more issue which was confronted in the matter of Rajendra K. Gupta versus Maharashtra Housing Development and another. Here the issue was whether the moratorium will apply to statutorily freeze occupation that may have handed over under the joint development agreement. So in this matter, a corporate debtor entered a tripartite joint development agreement with the party with regard to development of certain land. And corporate debtor defaulted in payment of loan for the development of land, and bank initiated the CIRP against the corporate debtor. Now during moratorium, the party to whom the land belonged, that is Maharashtra Housing and Development, served a termination notice upon corporate debtor stating that 30 days of the receipt of notice would be deemed to be terminated and the land with all structure would be repossessed. Supreme Court analyzed section 14D, which deals with the moratorium, and observed that section does not deal with any beneficial interest or legal rights of the corporate debtor in any property. It clarified the word owner, lessor, recovery of property will have to be addressed separately. In the given situation, corporate debtor only has a license to make development. It does not own the property. Therefore, termination notice would not fall in the ambit of moratorium. So Mahada was having a right to terminate. And similar ruling has been done in a couple of more cases also. Although there are one, I think I remember a judgment of in the matter of Noida Authority, I think I have covered later. I'll discuss that also, which is slightly in difference to what this judgment talks about. Another matter was with regard to the Indian Overseas Bank versus RCM Infrastructure. Very interesting judgment that whether the bank can continue the proceedings under SARFAESI once the CIRP has initiated. So in this matter, Indian Overseas Bank extended the credit facilities to the RCM Infrastructure. RCM failed to repay the debt, and loan account of the CD became irregular and was declared NPA. Demand notice under section 13(2) of SARFAESI was issued to the corporate debtor and its guarantor to repay the outstanding amount. Now, corporate debtor had failed to comply with the demand notice to pay the debt. 13(4) action of SARFAESI got triggered and symbolic position was taken by the Indian Overseas Bank. Now, e-auction notice was issued in 2018 by the appellant bank to recover the outstanding amount. Now, meanwhile, Section 10 application was filed by the corporate debtor to seek necessary protection under the Insolvency and Bankruptcy Code. That application was filed on 22nd October 2018. Auction bid, which was going parallelly, was received on 6th of November 2018. Second auction notice issued on 27th of November 2018, and the auction date was scheduled as 12th of December 2018. In second e-auction, 3 persons became successful bidders by offering a price of 32.92 crore for both the secured assets. On 13th of December 2018, the sale was confirmed. Now, successful bidder deposited 25% of the bid amount, that is 8.23 crore, as a EMD, and the Indian Overseas Bank issued the sale certificate also to them. And the purchasers were directed to pay the balance amount within 15 days, that is by 28th of December. Now, on 28th of December 2018, the purchaser wrote a letter to the bank seeking the handing over of the peaceful and vacant position of the assets and prayed for extension of time to pay the balance 75% of the bid amount till 8th of March 2019. And bank also agreed. Now, meanwhile, NCLT wide order dated 3rd of January 2019 admitted the petition filed by the ex-promoter of the corporate debtor. As a result of such order, under Section 10, CIRP got triggered and moratorium got enforced. Now, Appellate Bank on 21st of January 2019 filed its claim before the IRP. Accordingly, the bank, the balance 75% of bid amount was not yet received from the purchaser, hence was not to be excluded from the claim that was to be filed before the IRP. Now, during the pendency of CIRP, the bank accepted the balance 75% of the money which was due by 8th of March 2019. Now, bank submitted its revised claim to IRP on 11th of March 2019. IOB intimated about the successful sale of the said secured assets. The promoter of CD filed an application praying the NCLT to set aside the sale certificate issued by the bank, and wide order dated 15th of July 2020, the NCLT passed the order allowing the application and setting aside the sale made by the bank. Now, bank got aggrieved with this order, filed an application before the NCLAT. NCLAT rejected the appeal by order dated 26th of March 2021, and further appeal was made to Supreme Court. Now, Supreme Court framed 3 issues primarily: whether the act to foreclose under SARFAESI is prohibited on initiation of moratorium. Do the provisions under the Insolvency and Bankruptcy Code prevail over other similar laws in the country? And last, whether the sale-wide auction is said to be completed on payment of partial consideration. These were 3 very interesting issues which were before Supreme Court. Now, petitioners submitted, that is the bank, because bank has gone into Supreme Court. They submitted that the very initiation of voluntary insolvency proceeding under Section 10 was with mala fide intent and should be stopped as captured in Section 65 of the Insolvency and Bankruptcy Code if regarded as a malicious proceeding. Demand notice to the corporate debtor by the bank was challenged by the corporate debtor by application filed with the DRT, wherein no stay was granted. CD was ordered to deposit rupees 12 crore for stay on confirmation of the sale, which the corporate debtor has paid. After which, with a mala fide intent, the petition under Section 10 was filed to stall the sale proceeding. They also submitted that the NCLT order was passed on 3rd of January 2019, that is prior to confirmation of sale. Hence, the mala fide intent of corporate debtor to stall the SARFAESI proceeding. Such intention is made even more clearer as the liquidation order given by NCLT on 7th of February 2022 due to lack of credible plan by the ex-promoter. They further submit that upon perusal of order of NCLT of 7th of February 2022 would reveal that the delay caused at the instance of IRP who has been helping the ex-promoter. Since the moratorium under Section 14 of IB Code has ceased to operate, directing liquidation passed under Section 52 of the IBC, hence the secured creditor were allowed to realize their security interest. There is no bar on the appellant to realize its money. Now, bank also submitted that as per Section 54, sale was completed after receiving and confirmation by the bank of 25% of the bid amount. Hence, the fact that part of the bid money was received subsequent would not affect the sale process, which has been upheld in the many of the other judgments also. Now, the submissions which were made by the auction purchaser, that is the person who acquired these property, the impleading applicants supported the submissions made by the bank, obviously because their interest was otherwise getting affected. So they also contested that right of redemption under Section 60 of the TPA and the right of redemption has been lost on the issuance of the public notice of auction or tender as under Section 60 of the Transfer of Property Act. The applicant further submitted that the applicants were not added as party respondent in the proceeding before NCLT. After the successful auction purchaser show the mala fide intention of the corporate debtor, and that as per paragraph 21 of the Insolvency Committee report, the rights and priorities of the creditor established prior to insolvency under commercial law should be upheld to preserve the legitimate expectations of the creditor and encourage the greater predictability in the commercial relationship. Now, respondent finally submitted that respondent impugned judgment passed by the NCLAT as well as the order passed by the NCLT, and submitted that the title would be passed over only after receipt of the full sale consideration and issuance of the sale certificate, and that the said title cannot be conveyed to the auction purchaser merely upon confirmation of sale. It was further submitted that such contentions are completely in contrary to the provisions of the SARFAESI, as has been stated in the matter of Hindon versus State. They also mentioned that section 13(8) itself provides a right of redemption of secured assets to the owner debtor and has relied on the case of S. Karthik versus N. Subhash. They also submitted that upon approval of the resolution plan, in view of section 301, section 31(1) of IB Code, all the debt stand legally resolved, and the same is binding on all the parties, including the corporate debtor, employee, member, creditor, government. And clean slate theory and 238, these are the provisions which are to be considered. It was also submitted that the proceedings under the SARFAESI by the overseas bank and the receipt of balance sale consideration was violative of section 14 of moratorium, regarding the moratorium, as they have continued the action during that particular process, which was malified. It was further mentioned that impugned judgment passed by the NCLAT as well as the order passed by NCLT and submitted that the bank never challenged the order of NCLT to commence the CIRP on 3rd of January 19, and that the order of liquidation passed by learned NCLT on 7th of February 2022 was stayed by NCLT on 8th of March 2022. Now, what Supreme Court considered? Supreme Court mentioned that from section 14(1) that after initiation of CIRP, the moratorium for any action to foreclose, recover, enforce the security interest created by the corporate debtor in respect of its property, including any action under SARFAESI, that is, there is a complete prohibition for any action to foreclose, recover, and all. And this is clear from the legislative intent, as has been mentioned. 238 of the IB Code, it can be seen that the provision of IB Code shall have effect, notwithstanding anything contained in any other law for the time being in force. And judgments of innovative and principal Commissioner Income Tax versus Monet and Ghanshyam Mishra versus Edelweiss, all these judgments also were quoted. The court recognized the judgment of this court in case of Vidyadhar, where it was held that even if full price of the property has not been paid, the transaction of sale will take effect and title would pass on that transaction. However, court held the real test is the intention of the party. Now, they also considered the case of B. Arvind Kumar. The suit property was sold in a public auction, and the sale of which was confirmed by the district judge and the civil military station, Bangalore. The court is of the opinion that the property is sold by the public auction in the pursuance of the order of the court, and the bid is accepted and the sale confirmed by the court in favor of the purchaser. The sale becomes absolute and the title vests in the purchaser. It is held that the sale certificate is issued to the purchaser only when the sale becomes absolute. However, in case the court found that the title was intended to be passed only on payment of the balance consideration, then it would be a different matter. So there were other judgments also which were considered, and finally court concluded that there is no occasion to interfere into the judgment passed by NCLT and NCLAT. And therefore, it was held that after CIRP is initiated, all actions, including actions under SARFACI to foreclose, recover, or enforce any security interest is prohibited. IBC code is complete code in itself, and the provisions of insolvency and bankruptcy code will prevail. So what Supreme Court finally decided was that sale under statutory scheme as contemplated in Rule 8(9) of the Security Interest Enforcement Rules shall deem to be complete only when the entire payment for the sale is made and on issuance of the sale certificate by the authorized officer in favor of the purchaser. It was also rightly observed by the Honorable Supreme Court that the provisions of Section 14(1)(c) will have the overriding effect over the other laws. So accordingly, this matter was closed. There is one more matter, though little different in context, but very interesting one on moratorium. Recent one on 27th of April 2022, it was decided. It was regarding NDMC versus Minosha India. And the issue was that Section 60 Clause 6 does not contemplate the exclusion of entire period during which the moratorium was in force in respect of the corporate debtor. Matter which is not exactly, but not on limitation, but what Mr. Jaina was asking in the previous session. Here also the issue was that NDMC placed a purchase order to Minosha India. An agreement was executed. However, a termination notice was issued by NDMC to Minosha on account of certain breaches or inactions. Now, subsequently, when Minosha approached the High Court, Delhi High Court directed NDMC to hear Minosha and consider its representation. And while their communication dated May 2016, NDMC rejected the representation of Minosha. Now, Minosha invoked the arbitration clause in the contract, and NDMC in its reply on July 2016 refused to give their consent to suggest the name of arbitrator. Meanwhile, NCLT declared the moratorium and admitted the application, and resolution plan was also approved on 28th of November 2019. On 25th of November 2020, the Minosha filed an application under Section 11, Clause 6 of Arbitration and Conciliation Act, which was allowed by the High Court, Delhi. Thereafter, NDMC approached Supreme Court, and the key issue before the Supreme Court was whether under Clause Section 66, the entire period during which the moratorium is imposed could be excluded while computing the limitation in respect of proceeding initiated by the corporate debtor. Now, Supreme Court, after analyzing, mentioned that moratorium gets imposed on all proceeding contemplated under section 14. However, insolvency code does not expressly bar
ऊपर थोड़ा धनिया डाल देना
corporate debtor
पाव भाजी मसाला डाल के ना बस मिक्स कर दो
So what insolvency law mentioned, that insolvency law does not bar a corporate debtor from initiating proceeding against another party during the moratorium. Placing a reliance on section 17 of the IB code noted that the management of the corporate debtor is taken over by IRP. Therefore, resolution professional takes over as appointed by the committee of creditors.
हाँ ले लिया धनिया मत डालना अलग से सब में
प्लीज कैरम तो नहीं होगा ना
Now, Supreme Court noted, although the proceedings by corporate debtor to the RP are possible by 25(2)(b of the
Monica ji, your speaker is on. Sorry to
Monica,
interrupt, sir.
Madam Monica, please switch off mute.
Therefore, Supreme Court held that this might be a reason that the Parliament has excluded the period of limitation in regard to suits or application at the instance of corporate debtor under clause 60, clause 6. So this was a reason why the Supreme Court mentioned that this period will be excluded from the purpose of counting the limitation. But this is a matter which is in difference to here the corporate debtor was filing a matter. So for that purpose, whether the limitation will be excluded or not, that is provided in the section itself. But what Mr. Jaina was asking in the morning was little different, where the question was during this CIRP period, whether this entire CIRP period will be excluded for the purpose of determining the limitation which will be applicable to invoke a guarantee for the guarantor. So in that, I am still having the same view because these are not the recovery proceeding initiated. So this, to best of my understanding, will not be applicable in the case of that guarantor. But this particular matter is little different, and here you get, because the law has very clearly provided the provision in the act itself. Let me just take there is one more matter which is regarding the resolution plan, I think, which is recent one. So I'll take that judgment also, which is in the matter of Ruchi Soya Industries Limited versus Union of India, 17th of February. Now, once the resolution plan is approved by the adjudicating authority, all claims stand frozen and no claim which is not part of the resolution plan would survive. I think this crux is relevant. Rest, I think, matter we all know. Ruchi Soya Industries went into resolution, and after resolution plan was decided or was approved, one Central Board of Excise and Custom imposed a tax on the imported goods, and they tried to make a claim before the adjudicating authority by filing a writ, by filing a matter before the court for the purpose of surviving their claim. So Court said once the matter is before the resolution plan and resolution plan is approved, then it cannot be considered. 29A has been debated a lot. I think I'll not touch. ArcelorMittal is a landmark judgment. I'll just take one recent one. This Bank of Baroda versus MBL Infrastructure. This judgment, though, was passed on 18th of January 2022. This was in relation to 29A clause H. In this matter, MBL Infrastructure, set up by Mr. Anjani Kumar Lakhotia, availed the credit facility from consortium. MBL failed to honor, and few banks invoked the personal guarantee. Now, RBL Bank issued the notice under section 13(2) of the SARFAESI after duly invoking the personal guarantee, which was followed in a similar action by the other banks also. Now, Committee of Creditor in its meeting deliberated upon the impact of this particular amendment, which was introduced during the CIRP of MBL, and it was considered that the eligibility of respondent number 3 in submitting the resolution plan, who is of the view the same filed an application praying for a declaration that he was not disqualified from submitting a resolution plan under subsection C and H of the 29A. The adjudicating authority, by it ordered, held that it was eligible for the same. It ruled that since the personal guarantee have not been invoked and the respondent number 3 merely have extended his personal guarantee as such, there is no disqualification per se under 29AH of the Insolvency and Bankruptcy Code, as the liability under the guarantee arises only upon invocation. Now, resolution plan was approved by more than 75% of the voting share, and considering the techno-economic viability and feasibility, and same was approved by the adjudicating authority as well. Further, the other appeal and the interim application, including that of appellant, were dismissed on the above ground by the adjudicating authority, as well as the appellate tribunal. And appellate tribunal further confirmed the order of the adjudicating authority. Now, meanwhile, IBC went under the further amendment, and the appellant challenged the order of appellate tribunal, confirming the order of adjudicating authority in the appeal. Now, what Supreme Court observed? Supreme Court observed that respondent number 3, who executed the personal guarantee, which were invoked by 3 of the financial creditor, even prior to application filed, which attracted section 29AH. The eligibility can never be restricted to aforesaid 3 creditor, but also to other financial creditor in view of import of section 7 of the code. If you see the language of 29AH, that's what the court interpreted, that you did not see it in context of the person who has filed the application invoking. If the other persons have also invoked, that will also be considered as an invocation only. So the adjudicating authority rightly noted that it was accordingly approved after taking into consideration the techno-economic report. The plan has also put into operation, and as of now, MBL is an ongoing concern. The interest of 23,000 shareholder and 1,000 of employees needs to be taken into consideration, and 300 crores has also been approved by the shareholder to be raised by the MBL. The Apex Code stated that ultimate object of the code is to put CD back on the rails, and no prejudice would be caused to the dissenting creditor, as their interest would otherwise be secured by the resolution plan itself, which permits them to get back the liquidation value of their respective credit limits. Supreme Court hold that once an application for insolvency resolution is admitted on application of a creditor, then process would be one of rem, and therefore all the creditor of the same class will have a right. So this is subject to further compliance of invocation of the said personal guarantee by other creditor. So any other interpretation will lead to absurdity, striking at the very objective of section 29A. Ineligibility has to be seen from the point of view of the resolution process. It can never be said that there can be ineligibility qua one creditor as against the other. Rather, the ineligibility is to be participation in the resolution process. Exclusion is meant to facilitate a fair and transparent process. So this process was decided by way of concluding that 29AH has to be interpreted as this guarantee provision has to be considered in respect of any of the person, not necessarily the person who has filed the application. This Noida Authority matter was, I think, highly debated, and the issue which was in corridors of the judicial forums, various judicial forums, whether the lesser is an operational creditor or financial creditor, was settled by the Supreme Court. And very interestingly, Noida Authority executed a contract with the corporate debtor, wide which the bids were floated and a lease of a plot was granted for a period of 90 years. Now, appellant's position that it shall be considered as a financial creditor in terms of the Insolvency and Bankruptcy Code, though it was undisputed that it has not classified the lease with the respondent as a financial lease. So it was a case that lease was not classified as a financial lease, but the question that came before the discussion, whether the operating lease can also be considered for the parameter to classify one entity as a financial creditor. Now, CIRP initiated against the corporate debtor, and Form B, which is the operational creditor form, was filed, and subsequently Noida filed Form C, claiming a financial creditor itself. Now, adjudicating authority, appellate authority, found that lease deed did not have any clause relating to transfer of ownership. There was an underlying transfer of right to sublease, but the ownership of land per se was not transferred. Now, issue that was framed by the Supreme Court was whether the appellant is entitled to be treated as financial creditor within the meaning of Insolvency and Bankruptcy Code or not. Now, what appellant contended that there was a substantial transfer of risk and reward incidental to ownership from the lessor to the lessee, owing to the lessee's discretion to fix any amount of consideration it deems fit from the buyer, which is an element of paramount importance, to classify itself into the financial lease. Now, what respondent were given an option of upfront payment of premium along with the interest, and deed was financial in nature. Hence, the dues which were arising out of the same were financial debt in terms of the provisions of section 5 clause 8 of the Insolvency and Bankruptcy Code. Now, lease was involved as a deemed disbursement by virtue of financial facility. So thus, it was having a commercial effect of borrowing under section 5 clause 8F of the Insolvency and Bankruptcy Code. Then one more argument was that the appellant is has a statutory duty to carry out the planned development and the group housing. So Noida Authority was claiming these as a basis. Now, what the respondent claimed? Respondent submitted that the appellant has never demarcated the said lease as a financial lease in its book since the date of its commencement. And the classification is mandatory as per the objectives of the Ind AS and under section 133 of the Companies Act, otherwise it becomes a non-compete. Now, the terms of the lease were unilateral and tilted in favor of the lessor, as it does not take into consideration the interest of the lessee and deprives it of rewards it is entitled to, as a lessee is not permitted to assign a leasehold interest. There is a restrictive shareholding and no possibility of renewal of lease, no option for respondent to opt out, terminate the contract. In terms of mortgage, any increased value of the property would be at the disposal of the lessor. So these were the arguments taken by the respondent. Now, Supreme Court held that Noida Authority is not a financial creditor, as the lease agreement is with restrictive clauses and cannot be considered as a financial lease. Leasing of a plot with a restrictive clause did not amount to a financial lease, as has been decided in the matter of Asia Brown Boveri versus Industrial Finance Corporation and others. Further, rules of the accounting standard were also relied upon, and couple of other judgments in the matter of Pioneer Urban and Phoenix ARC and other. It was summarized that insolvency law is still in a infancy stage, is prone to misinterpretation. The debtor need to be treated as a financial creditor and become part of COC, interfere with the rightful claims of the other stakeholder under the guise of section 5 clause 8F. But the judgment leaves the ball in the courts of stakeholders of such real estate project who have smaller, though substantial claims to take decision in the committee of creditor, leaving behind authorities like Noida from patronizing and having the need to influence and or channelizing the CIRP unfairly. If leases were started to be treated as amount raised by the lessee instead of simple rental or premium, half of the population of the country would be a debt ridden. Very hard words were used by the Supreme Court in this particular matter, because there were many matters which are pending in this particular regard, which were considered for deliberation. Another very interesting matter, I think after that we will move to the PF and gratuity matter. If somebody has given an advance to the other party and the other party has failed to repay that advance, maybe due to some XYZ reason, whether it will be falling in the category of an operational creditor or in the category of a financial creditor. That was a question which came for discussion in the matter of Consolidated Construction Consortium CCC Limited versus Hydro Energy Solutions Private Limited. In this matter, the Chennai Metro Rail Limited made an order for supply of light fittings to CCL, which in turn placed an order to the one proprietary concern by way of 3 purchase order dated 24th of June 2013. Now, in order to satisfy these purchase order, the advance was sought by the proprietor concern for rupees 50 lakh, which was paid by Chennai Metro Rail Limited. Now, the project to be executed by Chennai Metro along with CCL was terminated, and CMRL informed CCL on January 2nd, 2014. And CMRL also informed to the proprietor concerned. And it demanded that money to be returned by the sole proprietor. Naturally, when the contract was terminated, so the money that was advanced to the sole proprietor was supposed to return that money. Now, in Treganum, the sole proprietorship concern was taken over by entity named as Hydro Energy Solutions Private Limited. And the main object was to take over the proprietor concern. So CCL sent a letter to proprietary concern asking it to return the money to CCL, and also stated that CCL would indemnify the proprietary concern against the claim of CMRL for the said amount. However, the proprietary concern rejected the proposal, and after series of meetings, the proprietary concern failed to remit the amount. Now, CCL was having no other option. Demand notice was sent. Receipt of reply was done. Section 9 application was filed, and Chennai bench of NCLT admitted the application. And on 8th of December 2018, the CIRP commenced and moratorium started. Now, this order obviously was appealed before the NCLAT, and NCLAT dismissed the appeal on 12th of December 2019. Now, CCL went to Supreme Court against that dismissal. Supreme Court considered the definition of operational creditor. Court emphasized upon the requirement as per provisions of the code for serving a demand notice. They gone into the minute details that what requires to be done in case of section 8 notice by way of form 3, form 4, how distinct they are, what is required in case of form 3, what is required in case of form 4. And basis that, Supreme Court elaborated that it is not necessary for a party to send the invoices along with the notice where there is a debt pursuant to any agreement between the parties. The court also stated that the operational debt occurs in lieu of any operation of an enterprise. In the instant case, since the project was to be undertaken by CMRL and CCL, whereby goods were to be purchased from the propriety concern, which in turn was to be taken over by the respondent herein, that is hetero, the said outstanding can be construed as the operational debt. So issue was that the advance which was made by CCL to the proprietary concern, which was now a company, whether this is the operational debt or not, because operational debt per se is the money which has been given or the money which becomes due against the supply of goods or services. Here, the advance was given and advance remains unpaid. Whether this will qualify as a operational debt or not was the essence question. So here, the distinction between form 3 and 4 was made, and it was mentioned that in form 4, you are required to mention name of the operational creditor, and it is language is that name of the operational creditor hereby provides notice for repayment of the unpaid amount of so and so amount as reflected in the invoice attached to this notice. Or if it is a form 3, then you have to mention the details of total amount of debt, details of transaction on which the amount became due, total amount claimed to be in default, particulars of security, and attach the copy of certificate of registration if you have, title, record of default, and the provision of law and the documents. Basis this, and considering the provisions of sections 8, since the notice claiming outstanding debt does not require an invoice to be part of the notice, the document which is evidencing the outstanding amount are good enough to be annexed to the notice under section 8 of the code. Accordingly, the form of contract for supply of goods and services between the operational creditor and the corporate debtor evidenced, though document can form part of the demand notice under section 8 of the code, cannot be considered, can be considered as a operational debt. There were previous judicial precedents also which were taken into consideration. So this contradictory judgment passed by NCLTs and the NCLAT regarding the character of advance has now been put to rest. The situations of the prayers of the advance were jeopardized owing to the fact that even if receiver of the said amount choose abandon its obligation, the prayer did not have a choice of filing an application for the said amount under the provisions of the code. Now, with the resolution, Supreme Court has given a substantial relief to all such cases. Now let me come and see if something interesting is there. I'll cover, otherwise I'll come to Now, let me take the provisions with regard to the provident fund and gratuity. And then based on the time available, we will take up the questions from the participant, and we'll see the cases, whatever are of the interest of the participant. But I want to cover this particular part in detail. So provident fund dues or the employee dues has been subject matter of debate since beginning. Let us understand what is the legal position first, and then we will see what the judgments have evolved over a period of time. Now, section 11, if I can say so. Now, we all know what is the provision with regard to the provident fund, with regard to gratuity. These are all social security instruments, provision to secure the social angle of the employees. Certain fixed amount is deducted from the remuneration of employee, and equivalent amount of contribution is done by the employer and is deposited to the employee provident fund or recognized provident fund, as the case may be, or it may be by the provident fund being maintained by the government or a trust maintained by the company itself. Similar provision is in respect of gratuity, and actuarial valuation is done in respect of provision, and every year the statutory auditor undertakes a valuation on the basis of actuarial, and difference in the amount which is required to be provided for is charged to the profit and loss account, and the interest of the employees are protected by way of these measures. Now, section 11, to be very precise, because 11 talks about a priority of payment of contribution over the other debt. If an employer goes into insolvency or is in winding up, so one says that these dues are to be paid in priority to all other debt in the distribution of property. Now 11.2 says without prejudice to subsection 1, if any amount is due from an employer, whether in respect of employee's contribution deducted from wages or employer contribution, the amount so due shall be deemed to be the first charge on the assets of the establishment. What does that mean? Amount which has been deducted, an amount which is due. So now let us examine. Now before that, let us complete one more fact, legal position. Now, para 29.3 of the EPF scheme, if I can draw your attention. Now 29 deals with a contribution. So it talks about what rate the contribution will be done, who will do what will go where, right? Now para 3 is relevant. Para 3 says the contribution shall be calculated on the basis of basic wages, dearness allowance, including the cash value of food concession and retention allowance, actually drawn during the whole month, whether paid on daily basis or weekly basis, fortnightly basis or monthly basis. Now, what is interesting, that provident fund becomes due only when the salary is paid. Let us take an example of a CIRP. ABC Limited has not paid the salary of maybe last 12 months. To their employees. Prior to that, all period, the salary has been paid. Now, question arises, the dues which are outstanding, whether that will include, whether the employee claim will include the provident fund dues also or not. During CIRP, the employee has worked, whether PF contribution will be made during the CIRP or not. Interest element may be further. So there may be a situation where company has deducted the contribution but has not deposited. An equivalent amount of contribution has also not been deposited to EPFO. This is situation number one. Situation number two, employee contribution has been deducted and deposited, but employer contribution has not been deposited. Situation three, employee contribution deducted and deposited. Employer contribution also deposited. So there can be many permutation and combination which can be there. In certain cases where you are doing a delay, the interest provision will also become invocable, and in certain cases the penalty provision will also become invocable. But one thing which is very sure is that PF dues are payable only on the time of payment of salary, not prior to that. So if I have not paid 12 months salary, then PF default is not there because I have not paid salary, so PF has not been paid. Many of the EPFOs have been claiming wrongly the payment of penal charges and the interest charges on this count. So we have to, as an insolvency professional, we have to be careful in considering their penal and interest demand in respect of these claims. Whether these claims are valid or not will depend what kind of default we have done in respect of provident fund. Now, another aspect which is regarding the payment of gratuity. So gratuity is payable. We all know that if I have worked continuously for a period of 5 years, so after superannuation, or maybe on my resignation, or maybe on my retirement, or maybe on my death or disablement. Now, where I am having lesser period of service, or the period of 5-year continuous service shall not be mandatory, where employee has passed away due to death or due to disablement. or he has been terminated. But in any case, that is not an issue. So point is that gratuity law section 4 and its proviso are relevant for the purpose, which gives the legal force to the payment of the gratuity. Now, if you see the section 53 waterfall, I need not repeat, we have discussed many times during the day, and section 238 of the Insolvency and Bankruptcy Code, which is a non-obstante provision that notwithstanding anything contained in any other law for the time being in force, the provisions of insolvency shall prevail. Now, definition of workmen also and workmen dues also is not provided in the insolvency law. You have to buy the definition from section 326 of the Companies Act. Now, workmen is as defined in the Industrial Dispute Act. Mark the difference between the workmen and the employee. Workmen, 24-month dues prior to CIRP are considered. Employees, 12-month dues prior to CIRP are considered. Now, what covers the employee dues means all wages, salary, wages payable for time or piecework, salary earned wholly or in part by way of commission or otherwise, or any compensation under the Industrial Dispute Act. All accrued holiday remuneration becoming payable. So all these components are part and parcel of your workmen dues. Now, interesting part is that if you come to para 4, all sums which are due to any workman from the provident fund, the pension fund, gratuity fund, or any other kind of, or any other fund for the welfare of workmen maintained by the company. This is also part and parcel of workmen dues. Now, if you go and read section 36(4)(a), clause 3. Now, 36(a) talks about what? 36(a), 36 clause 4 deals about what will not form part of the liquidation estate. So what it provides, that the following shall not be included in the liquidation estate. Among other things, it says that the amount which is due to any workman or any employee from the provident fund, pension fund, and the gratuity fund has not to be included in the liquidation estate. What does that mean? That has a very vast meaning. Vast meaning is that if I have created a trust for maintenance of the provident fund, during liquidation, the liquidator cannot use the funds which are part of my trust for the purpose of liquidation estate and distribution to the creditors, because these are the funds which are available for the benefit. Similar provision is in respect of recognized provident fund or EPF. So whether it is EPF or RPF does not matter, you will get the same position. Now there can be 3 primary situations and 2 sub-situations in each category. One is what will be the situation of claim of employee and workmen prior to commencement of CIRP. So unpaid dues of workmen for a period prior to commencement of CIRP. Now, in this situation also, there can be two situations. One, resolution plan is received. Situation two, resolution plan has not been received. Now, if a resolution plan has been received, the amount that the workman or employee shall be entitled to receive against the amount of their claims which has been admitted by the IRP is to be covered under section 30 clause 2b. This means that under a resolution plan, workmen and employees shall be entitled to receive the higher of the two amounts. Amount of average liquidation value if were to be distributed as per section 53. Number two, amount of resolution plan, that is total offered value under the resolution plan if were to be distributed as per section 53 of IP code. Now let us say the liquidation value was 100 crore and you received 150 crore during the resolution plan. So obviously your in 150 quantum will be more. So you'll be entitled to more amount. Otherwise, whatever you are entitled, if the liquidation value was to be considered, you'll be entitled to that amount if the resolution plan has been received. Now, if a resolution plan does not come and liquidation is ordered, what you will be entitled to? In such eventuality, amount admitted will be bifurcated into two categories. Claim for gratuity, PF, pension, and claim for wages. Now, as far as the provision with regard to PF, Provident Fund, gratuity, it will not form part of the liquidation estate. It has to be out of liquidation process and you will recover full amount. And if there is a shortfall, then it has to be out of the funds that liquidator may realize by sale of the liquidation assets. Now, whatever you have claims in respect of salary and wages, same will be as per 53 1F. Meaning that workman and the employee gets fund towards their claim for a period prior to CIRP. If there are funds available in the hand of the liquidator after payment of CIRP cost, liquidation cost, and claim of the secured creditor who have surrendered their security interest, pari passu with the claim of workmen for a period of 24 months prior to passing a liquidation order, and dues of employees for a period of 12 months prior to passing of the liquidation order. So this is a situation in respect of liquidation. Now, second situation. Second situation is claim of employees and workmen for the period which is covered during CIRP. So during CIRP, whether you will be entitled to your claims, if yes, to what extent you will be paid. Now here also again, two situations will come, where a resolution plan is received, second, where resolution plan is not received. Now, if a resolution plan is received, the amount that the workmen and the employees shall be entitled to receive against the amount of claims admitted by IRP, RP is covered under section 30 clause 2B. That means if you have worked, because this will form part of your CIRP cost. So whereas for a period prior to commencement of CIRP, there may be some shredding. Your amount may be subjective. You will put to category level 2 or level 3. Whereas during CIRP period, you will be considered as a CIRP cost. Your dues will be considered as a CIRP cost, and you will realize the full money in respect thereof, whatever you are entitled as per provisions of section 30 clause 2B. Now, if a liquidation is ordered, you need to submit your claim during the CIRP period. Now, there are two conditions primarily which are necessary, that you should be a going concern and you should have worked for keeping the company as a going concern. Well, your employment should have continued and you should have contributed positively towards the process. If these conditions are fulfilled, then this amount will be considered as a CIRP cost and you will be entitled to the money in full to the extent it is possible to be covered in the claim under section 53(1)(a). Now, claim of employees and workmen for the liquidation period. The order of liquidation will be deemed to be a notice of discharge. All employees, officer, workmen, except in those cases where the business of CD is a going concern. All employees will go off except those engaged specifically by the liquidator on the terms and condition agreed. To that extent, it will form part of your liquidation cost. And the liquidation cost is covered in 53(1)(a). So that will come as a priority claim. So this is a broad overview of the provisions of Provident Fund and the gratuity dues in respect of different scenarios. So issues are, what are the claim of employees, workmen prior to commencement, during the CIRP, during the liquidation, and there too also in a different scenario, whether the resolution plan is coming or resolution plan has not approved. And also the issues are regarding the interest which is payable to EPFO or the penalty which is payable to EPFO. So basis this, the issues can be decided. Now, what is the judicial evolution over a period of time? There are, I think, at least I can count, I think 10 or 12 judgment I myself has deliberated, primarily all are Supreme Court judgment. Precision fasteners versus EPFO. In this matter, the liquidator appealed against the attachment of property by EPFO, and he prayed for treating them as null and void. Now, NCLT Mumbai vacated the attachment order and held that the entire arrears towards the EPF should be paid before paying off to the other creditors. What does that mean? In a way, the adjudicating authority upheld the view, what we have discussed, that PF dues are not to be attached the properties attached by EPFO were wrong, and the action was nullified. Now, why EPFO office has attached was for recovery of PF dues, that is the amount what was deducted from the employee's salary or the employer contribution prior to commencement of CIRP. The law as it stands, because prior claims are to be processed as per either resolution plan or as per liquidation. Their EPFO cannot sit in judgment and take out a property in priority. It has to be done as per resolution plan, or it has to be done as per the law what is standing. So the action of EPFO to that extent was wrong. In contrary, there was a matter RPFC versus Karpagam Spinners Private Limited. In this matter, a contradictory view was taken. And in this case, NCLAT held that pursuant to section 238, it will override anything which is inconsistent with the code, including the Employee Provident Fund Act, and that the workman dues as payable under the EPF Act will not be considered in priority to priority of payment under section 53 of the Insolvency and Bankruptcy Code. Moving forward, the IBC to have an overriding effect over other laws where there is a conflict, does section 238's overriding effect be applicable to distribution of dues payable to workmen with regard to the provisions of EPFO or the provisions of Payment of Gratuity Act? Now this matter again came up for discussion before Supreme Court in the matter of Alchemist. This was decided by NCLT in 2019. This matter went up to Supreme Court. Alchemist versus Moser-Beer. It was held that even if there is a deficiency in the pension fund or provident fund or gratuity fund, the liquidator has to ensure that these funds are created and distributed that to workmen outside 53. Means all these dues were considered to be out of 53 and obligation was created on the liquidator to fill the gap, whatever it was having from the waterfall itself, from the assets of the CD itself. And in this matter, the tribunal held that liquidator has to provide these funds even if there was no provision of the funds by the CD. And again, it was stated that because of 238, the 53 waterfall shall not apply to the pension fund, provident fund, and the gratuity fund. And they will not be part of the liquidation estate. Now, this order was impugned by the State Bank of India, who was a secured creditor of Moser Baer, where a limited question was flagged before the appellate court whether the gratuity dues form part of the liquidation estate or not. And NCLAT decided not to interfere with the order of NCLT. So view what NCLT gave, that the liquidator is under the obligation to fund these provident fund and gratuity fund out of the assets of the CD was upheld. However, in the matter of Sawan Godiwala, who was a liquidator in the matter of Lanco Infratech versus Apala Shiva Kumar, the appellate tribunal, the liquidator submitted that there is no separate fund for gratuity and same cannot be done from running accounts of CD. And NCLAT in this case held, among other considerations, including the judicial precedent in the matter of Moser Baer, referred section 36(2) to reason that liquidator holds the fund in the liquidation state in a fiduciary capacity for the purpose of distribution among the creditor in terms of section 53 of the IBC, and further held that in a case where no fund is created by the company in violation of statutory provisions of section 4 of Payment of Gratuity Act, then in that situation also the liquidator cannot be directed to make payment of gratuity to their employees, because liquidator has no domain to deal with the properties of the corporate debtor which are not part of the liquidation estate. Very interesting. So Moser Baer order appeal upholding the order of NCLT in the Moser Baer matter by NCLAT, and then Sawan Godiwala matter, where the matter was decided differently, where the liquidator was relieved from the duty to fund the provident fund and the gratuity funds, in view of the fact that 36(2) gives the protection that these funds are out of the 53 proceeding. Now let us see how these two NCLAT pronouncements are different. One coming from Lanco Infratech and one coming from Moser Baer. In this matter of Lanco, NCLT directed liquidator should pay gratuity dues to the employees even when CD has not created a separate gratuity funds. And gratuity funds do not form part of the liquidation estate. Now, Moser-Bayer matter, NCLT by order held that PF dues, gratuity fund dues, pension fund dues are not part of the liquidation estate and cannot be part of the Section 53 dues. NCLAT in the matter of Lanco Infratech, while hearing the appeal, held that where there are no specific funds created for gratuity, the liquidator should not have been directed to make the payment of gratuity as per these workers entitled. NCLAT in the matter of Moser-Bayer upheld the judgment of NCLT. Now, what NCLAT held in the matter of Moser-Bayer, the liquidator cannot avoid the liability to pay gratuity dues to the employees on the premise that there are no separate fund created by CD. Whereas in the matter of Lanco, the NCLAT specifically held that it is not the liability of a liquidator if separate funds were created by, if no separate funds were created by CD. And therefore, there is a contradiction between the two judgments. Now, this matter of Moser-Bayer has been decided very recently by the Honorable Supreme Court also. Against NCLAT order, the matter went to Supreme Court, and Supreme Court has upheld again the order of NCLAT NCLAT mentioned that provident fund, pension fund, gratuity fund owned by the corporate debtor to its workmen, it does not fall within the purview of the liquidation estate for the purpose of distribution of assets under Section 53. And Supreme Court overruled the order of NCLAT in the matter of Savan Godiwala and Appala Shivakumar, where NCLAT has held that liquidator is not required to make payment of gratuity to employees if there are no separate fund for gratuity payment. Now again, by this recent order, the position again has been reversed. Now, we'll take two more judgments and then we'll open session for discussion. This matter was discussed in the matter of ABG Shipyard again. Sunil Kumar Jain and others versus Sundaresh Bhatt, who was a liquidator in the matter of ABG Shipyard. Now, question which came before this court was decided that wages, salaries of the workmen employees for the period during CIRP can only be included in the CIRP cost if it is established that RP managed the operation of a CD as a going concern during the CIRP and the concerned workman employee actually has worked during that CIRP process, which is what we discussed. So there is nothing new, but was very interesting judgment. So NCLAT has dismissed an appeal preferred by the employee of ABG Shipyard against the NCLT order, which has denied the relief to them with regard to their claim relating to salary involving the CIRP and a period prior to that. Against that order, the Supreme Court appeal was made. The issue that came up for discussion was wages, salaries of the workmen employees during the CIRP period and the amount due and payable to the respective workman employee towards the pension fund, gratuity fund, and pension fund. What will be the treatment? So, what was observation of Supreme Court? Supreme Court referred to provisions of Insolvency and Bankruptcy Code and observed that while considering a claim of concerned workmen towards the wages salaries payable during CIRP, first of all, it has to be established and proved that CIRP has continued as a going concern. During CIRP, the corporate debtor was a going concern, and that very worker has worked as a workman or employee. So, two-step formula has evolved. If you pass these two tests, the expenses will form part of the CIRP. Further, the wages and salary which are to be included in the CIRP will have first priority in terms of provisions of section 53(1)(a). All other wages which are period prior to commencement of CIRP will stand in a 53(1)(b) or C as the case may be. Now, if you see what legal provisions talks about, if you see 513, which is defining the CIRP cost, it includes the amount of interim finance, cost incurred, fee payable to any person acting as a RP, cost incurred by RP in running the business of the CD as a going concern. So in this process, in category C, you will fit into, and the employee and workman expenses will fall here. Section 20, clause 1 on the management of operations of CD. What it talks about, that the IRP shall make every endeavor to protect and preserve, and he shall have various authorities to employ the accountant, legal, other professional, to enter into contract on behalf of the corporate debtor, to modify them, to raise interim finance, to issue instructions to the personnel of the corporate debtor. So that is D, which is important, and to take such action as are necessary to keep the corporate debtor as a going concern. So if you fit into this criteria, this will also. Now 36(4)(a) clause 3, which we have discussed earlier also, that the following shall not be included in the liquidation state, which we have discussed, that any sum which is due to any workman or employee from the provident fund, pension fund, or gratuity fund. That is how it has got excluded. So these are 4 provisions, and 53 of the waterfall we have discussed earlier also. So this is the way the distribution has to take place. Now, it also mentioned that it will depend on facts of each case as to how you will determine whether the expenses during the CIRP are to be included as a CIRP cost or not. There is one more important point, that Provident Fund, gratuity, pension fund, because of 36(4)(3), these are outside the liquidation, that is outside 53, and these will be settled separately. Now, in 5 years from its enactment, Supreme Court has adjudicated upon various matters. These developments have enriched the jurisprudence of insolvency. The current judgment propounded by Honorable Supreme Court clarifies the position of workman and employee and set the law clearly regarding the claims towards the wages, salaries for the period during CIRP can only be included in the CIRP cost if it is established that IRP, RP manage the operations of a corporate debtor as a going concern. So this is the order. I think one more matter I will cover, that is B. Parmeshwara Udappa versus Assistant PF Commissioner and other. In this matter, NCLAT Chennai bench held that section 14(1)(a) regarding moratorium puts a complete embargo on any of the proceeding of the against the corporate debtor by any authority till the completion of CIRP. And moratorium covers attachment of bank account by authority, which is including EPFO also. And it is required to be lifted to grant CD a fair chance of revival. In this case, PF Commissioner has attached the bank account of CD before commencement of CIRP. RP has written him to release the bank account. He has not released. The legal question before the NCLAT was whether the attachment order on CD's bank account was imposed before initiation can continue during moratorium or not. So the order was that he has to lift the ban. One more matter, I think very interesting one from the judgment of Jet Airways, very recent order. In the matter of Jet Airways Maintenance Engineer Welfare Association versus Ashish Chavaria, and a Supreme Court Jalan Frisch Consortium versus Regional Provident Fund Commissioner, which was decided in February 2023. Now a 3-judge bench of Supreme Court in this Jalan Frisch Consortium upheld the judgment of NCLAT in the matter of Jet Airways, whereby the successful resolution applicant was directed to disburse the gratuity and the employee provident fund dues of the workmen of Jet Airways in its entirety. Now this judgment has opened up a lot of Pandora box, because on one hand we say that after the resolution plan is achieved and is approved by the adjudicating authority, it attains the finality. And all other dues are considered as null and void. So the idea is that, and section 32A also exists, which says that the successful resolution applicant essentially starts the corporate debtor on a clean slate theory. Clean slate theory means whatever has been considered while preparation of the resolution plan, nothing further can be added or subtracted. Whatever is there is there, whatever is not there is not there. So if a claim has not been considered earlier, because if this order is to be considered in spirit, tomorrow no successful resolution applicant will be inclined to participate in the resolution process, because I don't know what kind of liabilities tomorrow I may have. But the essence of this judgment, I think, on which the differentiating line exists, the argument of the other party was that the successful resolution applicant was fully aware about these liabilities. Despite that, they have not considered while preparation of their resolution plan. That is the only point of distinction which can come as a rescue for the other matters. Otherwise, this matter may have a lot of loaded implication for the times to come. So this matter, I think, if I can say about the way forward, how it has to be seen into, and how this matter will be looked into going forward, what is the solution? I think NCLT, I think the Insolvency and Bankruptcy Board of India needs to relook into the entire issue with regard to the employee and workman dues and the PF dues and the gratuity dues, and clearly provide a picture as to what has to be included, what has not to be included. Otherwise, this uncertainty will remain. So to bring a clarity, there is a need to amend the waterfall in terms of section 53, and they should take a clear stand on the subject. IBBI should also come out with a revised set of regulation regarding the treatment of PF gratuity dues and the treatment of interest and the penal charges where they do not directly accrue to the workers. This will save the liquidator from the dilemma. This will save the successful resolution applicant. This will give a clarity to the employees and workmen as well. So this is the way forward. That's where I will stop. I think I'll make the session open for deliberations further. Maybe anything we can now consider for discussion.
In the last thing, the interest and penalty is doesn't come under record to be paid in case of PF department demanding interest and demerit.
So now, not straight jacket answer cannot be given whether the PF dues. Now you have to state this. Now let us understand the interest and penalty can be due in respect of what. Now one situation can be that I have deducted the employee contribution and not deposited with the EPFO. Number one, and interest is payable and penalty is also payable on the same. That is situation number one. Situation number two, employer contribution not deposited. So there is a interest and penalty on the same. Third is during CIRP period, I have deducted but not deposited interest and penalty. Provident fund. So interest and penalty is leviable during that period also. And same for the employer contribution also. Now let us focus on these four situations.
One is the company has paid all the bills, but the delayed in submission of return is there.
Delay is prior to commencement of CIRP. Prior to commencement of CIRP, interest will not be payable. it will, if at all EPFO has to claim, they have to file a claim before the resolution professional.
Okay.
That cannot be claimed as a matter. See, anything which is prior to CIRP has to come and sit in 53 only.
Okay. Okay.
You cannot ask a priority over your dues, that in the gap that you are protecting or you are maintaining the funds of the EPFO and you claim the interest as a matter of priority and you attach the property. That is not the law.
Okay. 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 Thank you.
The attachment is also barred and claiming a priority is also barred.
They come under 53 only as per the water.
They'll come in 53 only.
Okay, thank you. The only thing that we have not discussed that rainbow judgment and regarding
Rainbow judgment we have discussed. I think you are not there in the first session.
Sorry. I will let you.
Yeah, we have discussed the rainbow judgment.
Sorry.
No problem. Yeah. Any issue that you think, though we have not, maybe we have covered quite a lot judgment of, especially focus was on the recent last 1 year judgment, which has been delivered during 22-23. Maybe by and large, we have tried to cover all the important judgment. Maybe some of them may be missed out, but if anybody wants to have a specific input, we will be able to make discussion thereon.
So kindly share the PPT.
Yeah, I don't have a PPT as of now, but I'll share certainly a compilation for circulation to the participant. This is what I'm sharing. I'll share.
No,
this.
sir. What we mean is that whatever you have presented in here, that word.
I will do that. I understand.
You can put in the chat box. We can download immediately. That's what.
I will do that.
Okay, that's better.
Or any other interesting observation that anyone has came across in any of the ongoing CIRP or the liquidation process. Maybe we all can benefit if anyone can share, or anything contrary to what we discussed. Maybe I'll stand corrected if anyone has got any experience with regard to any of the processes practically.
Sir, I remember having seen one Hyderabad NCLT judgment, I think, sir, NCLT judgment, which made a distinction between the PF members' contribution and company contribution as a regular to be paid by liquidator, whereas the penalty and interest were considered as a governmental dues when they were pushed to the last part, which is the governmental dues part. So
we are also saying the same thing.
No, but here now that SBI versus Moser Bear thing,
the recent judgment of February 2023, which has upheld the judgment of Savan Godiwala enclad judgment.
No, sir, once you have SBI versus Moser Bear Supreme Court, then that NCLT may not be of much use, no?
Yeah, so exact judgment, because what is falling from Supreme Court in this matter is upholding the judgment of NCLAT in the matter of Savan Godiwala, that is Lanco Infratech judgment. NCLAT Lanco order is upheld. That
so there the entire PF dues, so including interest and penalty. Is it that way, or how is it, sir?
No. It was only in respect of funding of the liability. I don't know.
So which includes interest and penalty?
No, I don't think it has to be interpreted that way. I will say.
No, because, sir, when the PF people come to our office, what they say is that they have to pay the members interest. Supposing it is deducted for past 2 years, we did not remit. Okay, now the member is asking, employee is asking the PF department to give interest for that period. So unless the company pays the interest to the department cannot pay to the employee, no?
Yeah, I understand, but still I have my reservations with regard to the payment of interest and penalty, right? I'm still, there are two things to it, because the judgment essentially talks about the corpus which is created, which is lying separate out of 53 process, right? So to that extent, it has to be funded. If it is not already funded, it has to be funded out of the other assets which are available. That is what the finality has in the matter of SBI versus Supreme
It's
Court.
only the principal, not the interest and penalties.
That is what I understand. From reading the judgment, I can read it again. What is falling from the judgment is, to that extent, it has to be funded. But yes, since you have highlighted that the interest and the penalty can, I think, because then it will become detrimental to the interest of the other stakeholder as well. To that extent, I think it may be okay, but that has to be, application also has to be seen from the other perspective, where let us say the other funds are not available, or if the funds are given or made available for the PF and the gratuity dues, maybe the other stakeholders' interest is adversely affected. So what they will do in those cases also has to be seen. Maybe if somebody has done a fraud and all the PF and gratuity dues had not been deposited at all, now a huge liability may be there. Your total sum corpus, what is assets corpus which is available, may not be sufficient even to meet that liability. In those cases, what will happen? Needs to be deliberated into, because this is a very recent judgment. Whatever understanding I could make, whatever limited research, because these are very long judgment running into long number of pages, whatever little summary understanding from the records I could make out is coming this way, that for rest of amount, I am very sure that this has to be done that way. But as far as the interest and penalty is concerned, I need to find out specifically whether that will be required to be captured or can be covered in the liability or not. If that happens, then I think the attachment order and the other order will also become justified in that case. If that
attachment may not be correct, because the RP has to continue the operations for which need bank accounts. So if the PO department comes and attaches the bank account, then
no, I'm not saying to that extent. I'm saying ki if that action is justified, and if RP is not making the payment, so to that extent he may prefer an application to the adjudicating authority also. So that has to be looked into. It's I'm not in a position to offer immediate comment. Sorry.
Hello.
Yes, yes.
Amiji, it was a very interactive and a very informative session. Amiji, while discussing, you said that filing of the claim is possible, which is barred by limitation.
Filing of claim, yes, is possible. It depends ki whether you will be able to. Now, in limitation, we discussed many aspects. One of the aspect which the Supreme Court has even quoted, that to as against the provisions of the Limitation Act 1963, Article 137, which is applicable in case of insolvency, if I go for filing a civil action, if I have delayed, if I am filing an application beyond limitation, I have to file a separate application for condonation. But in case of insolvency, you need not file a separate application for condonation, but you have to give a justification, and NCLT or NCLAT in its own wisdom can always allow the admission of that particular matter. Maybe it is barred by limitation. So that power has been vested with the NCLT to admit, maybe it can be one of the argument that these are the circumstances, these are the reasons which has prevented me to come before the adjudicating authority in the time frame of the limitation as per 137.
So basically, RP is not having that power. It has to be referred to the adjudicating authority to get it admitted.
No, you are saying, acha, now
See, what I'm trying to say,
you are saying after admission, after commencement of CIRP,
right,
and RP, if I am getting a
claim,
time barred,
yes,
admit it or not?
yes.
I think, see, there is no difficulty. It's a call of a RP. If somebody asks me, I think answered that also, whether a corporate debtor has a right to make a payment of a time barred debt or not. Answer is yes, he has a right to pay. Whether he want to pay or not, that's a different story. So it's a personal call.
Sir, it's not a question of right to pay. Does he have an obligation to pay? If he doesn't have an obligation to pay, then you need not. I have a right to pay, give donations also. Corporate debtor has a right to give donations also. That's okay. But here, does he have an obligation to pay? If he doesn't have an obligation to pay, then RP cannot admit.
So, Raviji, as far as the obligation is concerned, obligation is there. Maybe the other person has no legal remedy.
No, sir. If you see the definition of claim, just if you can show the definition of claim, sir, I think it is there something.
Yeah.
Where the definition of claim or something is there, no?
They are saying a legal right, but that is from the context of admission. I want to make a difference between these two things, and I have seen personally in many of the matters where the time bar debt also had been allowed to be admitted. Ultimately, what will happen in the case of liquidation? Tomorrow, if our entity goes into liquidation, so are we saying that though I have a claim, but I cannot file because it is time barred?
No, if it's a time barred, I would have simply replied to him saying that this time barred, so we can't admit. That's correct in my view. But anyway,
the same was my view, because we had received such kind of a claims which were time barred, and basis that even I had also not accepted those claims.
No, but does your balance sheet show it as a liability?
No, the balance sheet is not reflecting that amount.
Then that's it.
See, basically, the creditor, what I am talking, it was sort of a JV.
Right, JV is a partnership. No, JV is a partner.
Yeah, but he was a financial sponsor for that particular project. And as per the terms of the agreement, he was classifying it as a financial, being a financial creditor, where interest and other elements were also coming into the picture.
No,
but when I was analyzing the papers, it was already beyond the 3 years time span.
So here claim is defined as means a right to payment, whether or not such right is reduced to judgment, fixed, disputed, undisputed, legal, equitable, secured, unsecured. B, right to remedy for breach of contract under the law for the time being in force if such breach gives rise to a right to payment, whether or not such right is reduced to judgment, fixed, matured, unmatured.
Just see the creditors, a creditor and a creditor. Good answer. Creditor
means any person to whom the debt is owed and include a financial creditor.
Right. Then you see, then you have to see the debt definition next to that.
Means a liability or obligation in respect of claim.
Right. So here there is no obligation to pay, no?
No, you cannot say. That is what I'm saying. Obligation to pay I have. If I have taken a money from you, I have an obligation to pay. Whether
it's not a legal obligation. We're talking
about legal obligation. If
legal obligation because of a right term. This one, see, if you had filed an application in NCLT, it would have been rejected.
No, it is hit by time barring. That's a different matter. if I have taken a money, I have all the time obligation to pay back. Will you be able to, maybe you will be able to write it off from your books that you don't have any obligation. That's a different matter. That's a following of a particular process. But as far as the liability is concerned, I will always say that there is always an obligation to pay, and the way it has been worded in the definition of a claim, the right to payment, the other person has a right, whether he will be in a position to file a claim or not, that's a different matter. That's a limited point. So he will not be allowed to initiate the CIRP process. But as far as the filing of claim is concerned, I think that should not be barred. In liquidation, if you just stretch this argument little further, after liquidation, nothing survives. So if in liquidation stage also the person is not allowed, who has maybe a time bar debt, will not be allowed to file a claim, from where he'll be having a remedy tomorrow.
He lost his remedy already because of time bar.
Amitji, in my view of the matter, in case of where a claim is time barred, the remedy goes.
Even if it is a running, even if it is a normal company,
Without
even if it's a
any
normal
remedy.
company, his right is anyway gone. No? Suppose not in CRP or liquidation, still he doesn't have any remedy.
No. Once a debt becomes time barred, the remedy goes. Only the right remains.
So, all right, I am saying remedy in the sense a legal remedy in the legal forum. I am not in a legal forum.
No, you are a legal, you are appointed
No,
by
I
the
am not
court.
in a, once the CIRP commences, I am not in a legal forum.
No, once RP is there in charge of the corporate debtor, he has to act in for the best interest of the corporate debtor. He cannot admit the time barred claims, in my view of the matter. Even NCLT is not admitting any claim. They are dismissing in limine any petition which is filed qua the time barred debt.
So, Dr. Sir, my respectful submission is that if that is the scope, then it will, the role of a RP will become quasi-judicial. He will have to adjudicate in every matter that whether the limitation has passed or not. What the court is not able to do, what the NCLT is not able to do, that the role that adjudicating, that the role the RP will be required to do.
Nice, sir. Supposing we reject it as an RP level, suppose we reject it, then he goes to NCLT.
Yeah.
NCLT is definitely going to reject only.
So for rejection also you have to apply.
Right, we'll say that is a time barred. So the reason we gave is time barred debt. So we'll reject it.
In any case, RP is required to verify the claim. So verification includes the documents on the basis of which a claim the claim is being made to the RP. And when the liquidator or the RP sees that the document on the basis of which the claim is being filed is time barred, and there is no remedy available for the time barred debt, then it's not necessary for him to collect the claim. I think so.
So the
I
problem
think
is
I
that
have got. I have
It cannot stand the test of law in any forum.
Yeah, I agree, but yeah, maybe because I am privy to a couple of at least orders. Because individual processes, nobody is aware about the other processes, but NCLT has certainly admitted many of the claims which had been time barred in the past, and they have been maintaining this, and that was a position even in the winding up proceedings also in the old law. You may be appreciating that position also, that even till the last leg, when the liquidation dissolution order was getting passed, and if single asset was remaining, until that time also, if somebody has filed a claim which was time barred, the authorities have considered and have allowed for the purpose. Maybe I'll just pull out those judgments and maybe I'll discuss with you also. I believe that there has to be Now, I'm only concerned that whether RP will not, because he has a limited role in collating. And at that point of time, if he sits into all this judgment, whether it will be justified on his part or not, that's a dilemma that I'm having at back of the mind. Whether it will
Yes, sir,
be.
even in such a case, suppose the claim comes, what we normally do is that immediately we'll compare it with the books of accounts.
No, if you don't have a books of accounts.
No, at least at some stage you'll be having, no, at least 2 years old, 3 years old, 4 years old books of accounts you'll be having.
No, you
at least compare with that. So if it is there, acknowledge it as a debt, then you have to admit. If it's not there, then
that is again starting of the limitation. I mean, then the fresh, time of limitation will come into existence. But if there is no reflection or there is no acknowledgement of the debt itself, and because of that, there's no continuation. So that then it becomes a lapse. And again, once we start the process in CIRP, but obviously the moratorium and other things come into play. And then in the process of the liquidation, again that claim calculation can come. And one more thing over here is like, again, the RP is only supposed to verify the claim.
Yeah.
So
that's what I agree, Abhijit, because the role of a RP, IRP, especially when he publishes the invitation for filing the claim, that is a very limited window, and in majority of the cases, you don't have access to all these things, records and everything at that point of time. Maybe you will have the access, so at that point of time, what you are doing, you are only collating on the basis of document what he has submitted. You are not even able to verify it from your books of account. So if you don't have access to books of account, are you rejecting those claims? I don't think you have.
There's a dangerous statement. There is a dangerous statement because you will add up all the claims that you have received, then your COC will go to a task. Supposing you form a COC based on just claims received without, if you say the same statement saying that I can't verify the claims, I'll admit whatever claims are received from financial creditors. Somebody making a huge claim, you become a big member of the COC.
Collating word is to be interpreted because collating has a very limited meaning. There you cannot sit into the judgment of deciding and adjudicating anything. That is a role in your role as
But then how do you justify a COC formation without verifying them?
So that is a collation process basis the documents what had been furnished before the IRP.
Mr. Amit, I have to make one point. If we look at Form B, which is prescribed format for filing claim of the operational creditor, there is item 7, which says how and when debt is incurred. So if the time period is irrelevant, then this column would also be irrelevant.
No, I am not saying, Dr. Saab, I am not completely denying. I am buying your argument and buying the argument of Raviji also. My only difficulty is that if I extend this view, then the role of RP gets to the position of a quasi-adjudicating authority.
No. That's what I'm trying to say. In my view, because there is a specific column in Form B about when the debt incurred. When the RP has to look at the form, then immediately he comes to know that this is a time-bound debt. There is no question of adjudication.
Right.
Kindly see Form B in row number 7. It's clearly mentioned when the debt is incurred. And I don't think RP can close his eyes on the
now debt incurred and from where the limitation will start, I think the timelines are different.
See, suppose I am a operational creditor and I write this date 4 years ago, suppose, and as an RP, he has to look at this date. He cannot close his eyes.
No, all right. I am saying maybe there is a acknowledgement in the books of accounts. Maybe the debt is 7 years old.
If there is acknowledgement in the books of accounts, then there is no question asked.
RP can ask the information and if there is any later acknowledgement.
So that is where
That is where the role of RP comes, but it cannot be considered as adjudicatory role in any case.
Okay. Maybe anyone.
That's my view. I mean, I'm not saying anything.
I agree. I am also trying to just understand to what extent we can. I'll pull out those judgments where the adjudicating authorities have considered and directed for admission of those time-barred debts also. Let me pull out those at least 2-3 judgments I am recalling. I'll just pull out and I'll share it to you also.
And then there is column 11 also, which says list of documents attached to this proof of claim in order to prove the existence of the claim. So in response to it, if there is any subsequent acknowledgement, that has to be mentioned actually.
Maybe it has to be looked into that way. Maybe we'll revisit this subject and become little more wise. Each day we are evolving with something new. So this is something which is to be
Sir,
into.
when I passed this exam 5 years back, we were told that we have borrowed the whole scheme from London and all that, whichever is successfully being implemented. So we thought that we have a ready thing which we can simply take and adapt, not like our. But now we are having so many problems after doing that.
So there is nothing ready-made. I think India is a land of innovation, and with that innovation, I think we have evolved significantly faster than any other territory. And
you're right. No, that way speaking, if Companies Act has only one amendment per year, Income Tax Act is amended only once in a year anyway. So whereas here you find.
Yes, that I agree. Means there are good number of changes and tracking, especially the
tracking the amendments is becoming very tough. That's true.
Tough. So that is the challenge. Means as a liquidator, as a RP, you are supposed to perform your duties in line with what is the current position, so that you avoid any consequences tomorrow, and you are not fallen into any non-compliances and breaches also, and avoid the litigation also. So it's a quite Herculean task in terms of means the responsibilities what we professionals shoulder on ourselves. But yes, I think most of the people are able to cope with all these challenges, and together we are able to learn and exchange the thoughts, and this is where we are able to at least keep applying and learning the knowledge.
So there's actually what you say is reflecting on the number of IPs, because earlier there were more than 3,000 IRPs available. Okay. If you see today, it has come down to 2,400 something. That's what I could see 2 days back.
So it has got multiple factors also. I think one of the major factor being that new number of admissions has also got drastically down. So the IBBI as a regulator taking very stringent action also is one of the factors. So everybody is weighing its pros and cons. The people who were into the practice profession as a chartered accountant or as a cost accountant, they are also evaluating that if I have to choose between one, so what is best? Should I
worth the risk or not?
Absolutely. I think that's also one of the parameter which is being contributing to the numbers when we are talking about, I think.
But you have done a tremendous job, sir. Continuously is from morning 10 to literally till 5:30 with a half-an-hour break. That's a great job done.
I'm thankful that with interaction of all of you, I'm able to learn something and a lot of takeaways, at least for me. I don't know about how much I had been able to contribute to value addition to your knowledge, but it's certainly a lot of good point for me as well. And for during the preparation also, you tend to update yourself with the latest knowledge. So that's a takeaway for me, at least, and I'm sure we'll keep building this brick by these programs through ICSI, IIP as well.
If you can keep that presentation, whatever word file, what you put in the chat box, no, so we'll be able to download it.
So Nitin,
Sir, sure, sir, sure. Once you send it to me, sir, I'll share it with all the participants.
I will do that. I will do that.
Please,
It was very good session where you have compiled all the judgment. Really good knowledge on that.
Thank you.
Right, sir. So, sir, thank you very much for your time. Touching about so many subjects. I was not even thinking that you will take up so many different topics and being exhaustive with everything. So, thank you very much.
Thank you, Nitin. Thank you. Thanks to all the participants also for giving the opportunity to discuss and deliberate with all of you. And I hope the Sunday was worth investing. It has not gone into.
Absolutely.
One more thing, sir. We will get any certificate for this for claiming the this hours, or we have to simply.
Sir, okay, from
I think Nitin will be able to answer.
Yes, yes. So
there is a process that you have to follow. You go on your IBBI login. You click on CP icon, and there you have to add and claim your CP hours. Now, basis the program invitation, I think what is required that Nitin can tell.
Yes, sir. So we will today itself be sending a confirmation mail to all the participants, informing that we confirm their participation and they're entitled to these many CPs as per the IBBI guidelines.
Nitin,
so
we can attach the receipt also, na?
Not receipt, sir. Receipt is just a payment proof. Participation proof is the mail that we send.
It has been mailed?
No, he will mail it before.
Sir, we'll send it today.
Okay, fine. So we have to attach that.
Yes, sir.
Okay, fine, Nitin. Thanks.
Thank you, sir.
Right, sir. Right, sir. Thank you, sir. Thank you, sir. Thank you, everybody. Thank you.
Thank you.